Yes.
May I please allow? I'm seeking for listing, your lordship, one old matter, your lordship. In last it was listed on 9/5/2025, and thereafter it has not been listed.
2000.
25.
Hmm.
9/12/2025 last was listed.
What do you want?
I'm seeking listing this matter, your lordship, on Monday, your lordship.
Not Monday.
Yes.
After next Monday.
No, but the next Monday, your lordship.
Yes, next Monday. You put that at 25.
Wait, please, your
Hmm.
lordship. I am also playing for listing along me to for on next Monday.
Next Monday.
May I please, your lordship? May I please, your lordship?
May it please your lordship. Lordship, I beg to mention for listing of a writ petition. Lordship, there is some urgency. Lordship, the petitioner was working as senior engineer in NID and he was opting for PhD. Now the NID has rejected his NOC to pursue PhD, Lordship. If his case has not been considered, then he will lose the chance to pursue a PhD in Tezpur University, Lordship. Kindly day after tomorrow, Lordship.
Not day after Monday.
Monday. Much obliged, Lordship.
May I please, your lordship? My lord, I beg to mention item number 22, my lord.
20? 22, yes. Yes. On the prayer of Mr. F.L. Laskar and counsel for the petitioner, let this matter be listed after 2 weeks.
Lordship, I beg to mention item number 4 from the daily list.
Oh.
4. Engaged senior counsel has some personal difficulties, lordship. So kindly matter will leave on Monday.
Item 4.
Item 4.
Okay. On the prayer of Mr.
This again.
This and counsel for the list this matter after 2 weeks.
Monday.
After a week. Huh?
Master.
Wait, please, your lordship.
Yes.
Praying for adjournment of item number 51, lordship.
51.
We have taken consent from the other side as well as the review petition was listed tomorrow, lordship. So I'm
50.
praying for adjournment of this matter, lordship.
51. Okay.
Lordship, I'm
You are for petition. On the consent of counsel for the petitioner, Mr. D. Mahanta.
Ati go, your lordship.
T.
On
Gowai,
behalf of the
appearing on behalf of Mr. D. Mahanta, MS so-and-so, and the counsel has made a request for adjournment of the matter after 2 weeks.
Because lordship, review
Adjournment of the
petitions-
matter
2 week, lordship. 2 week.
Huh?
2 week, lordship.
For adjournment of matter for 2 weeks, huh? Praise the Lord, list after 2 weeks. 2 weeks, huh?
They pay fix, your lordship. That will.
Obliged, lordship.
Yes, next.
All right.
May I please, your lordship, I beg to mention item number 60, lordship. Our matter is taken with other writ petition, lordship. Our writ petition prayer is different, slight difference, lordship.
We don't know, we'll see.
Segregate and list.
Why this is listed for orders,
Yes, lordship.
55 to 60. 55 to 60.
Lordship, specific, my matter is lordship 60, lordship. So in my writ petition, lordship, prayers different, lordship.
What prayer? What is your prayer in the writ petition?
Lordship, I am not ready to.
Huh?
I am not ready for today,
If
lordship.
you are not ready,
Just one week, lordship.
we'll see, we'll see. Have you
Okay.
taken the consent of this? Have you talked to this other petition, learned counsel for the other petition, writ petitions?
Okay, yes, sure, lordship.
You talk to them. We'll take it up. We're not adjourning, take it up. Listed for orders, we'll see. Order, which date?
My lord, page 39.
12. Yes, and Mr. M.U. Mandal, learned counsel for the petitioner, decision application under section 11 and 12 of the Contempt of the Courts Act 1970, read with Article 215 of the Constitution of India, alleging willful disobedience and deliberate violation of order dated 12/12/2025, passed in WPC 6678 of 2025. List of issue notice returning below 4 weeks. And counsel for the petitioners to take steps for service of notice upon the so and so within speed post as well as the usual process within two working days. This after 4 weeks.
May I say, my lord, on interim, my lord, prayer.
Hmm?
My lord, the gentleman is suffering from, my lord,
How
various.
can we have a,
My lord, pendency may not be barred to them to
Sorry,
release, my
sorry.
lord, salary.
sorry, it's not appropriate.
Plus.
Yes, instruction.
Civil instruction.
Hmm?
I need some time, my lord. Next week, any day, my lord. My lord, we have filed additional affidavit, my lord.
Saying what?
My lord, bringing the notification, my lord, on the basis of which, my lord, the impugned order has been passed.
Ah. Where it is?
In additional affidavit, my lord.
Ah,
Page 38.
ah. Regarding the affairs and administration with reference to the the application in order received from. What is HOI? What is HOI?
Head of institute, my lord, from
The
the,
details about the cunning and illegal activity of President MSO. What is this?
on the basis of, my lord, the president has been removed. He has no jurisdiction, my lord, as per Rule 13.
Hmm?
There is a procedure, my lord, Rule 13, my lord, can you see Rule?
No, we have taken note of it. That's why we want the instruction. Why?
So.
Heard Mr. So
in
and
the
so,
meantime,
learned counsel for the
Impugned order,
petitioner.
kindly be state, my lord.
No,
in
unless
the-
we issue a notice, how can we do that?
Notice has not been issued.
That's what I'm saying.
Sorry.
He wants next week. We have taken note of your submissions, your case, and then that's why we wanted to have a instruction. Under what circumstances, whether it's correct or not. All right,
Got it.
next week. Heard, Mr.
Orally, my lord.
Arali, learned counsel for the petitioner. This court on 04/05/2026, having considered the issue invoked, directed the learned standing counsel elementary education to obtain instruction. Mr. Hauber, today Mr. P.K. Bora, learned standing counsel. Elementary education. Phrase for a week's time, as he has not received the instruction list of. Considering above, let this matter be listed after a week.
19,
And-
19, my lord.
On the next date, Mr. Bora, learned standing counsel, shall invariably place the instruction.
Okay. Obliged.
Item 3.
Date 3, I think.
My lord, kindly pass over for the time being, my lord.
Why?
Anyways, late. Anyways, late.
What is the matter about?
Matter relating to appointment, my lord, maybe. I'm not aware of heck, actually.
Heard, Mister, you will issue notice.
My lord.
Why you are not allowing?
Contextual employment.
Doesn't matter.
Just, not, it is of discharging his duties, my lord.
Huh?
He is not discharging his duties, my lord, as per his statement itself, my lord.
What is it?
He is not discharging his duties, my lord, as per his
So
statement.
he has not joined after the
My-
appointment. Issue notice. Heard, Mr.
Gauhati.
Learned counsel for the petitioner. Agreed by, no, the petitioner is a contractual assistant teacher. No, the petitioner is an assistant teacher. Assistant teacher on contractual basis, appointed on contractual basis under Sarva Shiksha Abhiyan, Assam, who is agreed by the action of the respondent authorities in not allowing him to join his service in the school, has preferred this, has instituted this writ petition, list of petitioner. It is the contention of the petitioner that despite his several efforts, despite his efforts to join in the school, after her or he or she, after his appointment as an assistant teacher, the
2024, madam.
oh, it's okay. The respondent authorities illegally and arbitrarily and illegally have not allowed the petitioner join in the said school. Join him in the service. List of next para. Issue notice returnable by 4 weeks as MS S. Sutia Learned Standing Counsel interest appearance on behalf of all the respondent. Appearance on behalf of respondent number 1, 2, 3, 4, 5. Yes, 3, 4, 5. 3, 4, 5. No formal notice need be served. No, 3, 4, 5.
For SSS separate.
1, 2, 3, and 4. Yes,
1,
no
2, 3.
formal no formal notice need be issued in respect of above respondents. Our extra copies to answer. Learned counsel for the petitioners to take a stage for service of notice upon respondent 5, 6, and so on. Huh? This after 4 weeks.
Fine. My lord, pass over the timing, my lord.
What is this? If it is a notice, then why we should wait for that?
Yeah. Your photo that's all of that from time.
Hmm?
Taken.
Well, other day also it was time being passed
No, no.
over.
You are, what is his prayer here?
Chemistry, MSc examination from the university.
Hmm.
And she cleared first semester, second semester, third semester. In fourth semester, one paper she got back. And now she wants that either three grace marks should be given to her or a special examination should be convened. So your lordship may issue notice, I shall take instruction. It's in. Oh, moon apni jana hai.
By heard Mr.
Gauhati.
Learned counsel for the petitioner. By filing this writ petition, petitioner is praying for our 3 grace marks in organometric metallics and proteon organic chemistry within bracket GSM for page 11, 9 and 11. Huh? in the fourth semester exams, wherein she has been, wherein she has scored 3 marks
3 marks.
short, 3 marks less, 3 marks short in to the pass mark, right?
Right.
Pass mark. Next petitioner was a student of postgraduate within bracket MSc in chemistry in the year 2000 for the session 2019 to 20 under the Bodoland University, who claims to have cleared first, second, and third semester exams in organometallics and proteonorganic chemistry. Next para. No, continue. In the fourth semester, which was conducted during the period of COVID-19 pandemic, and due to inadequate time to prepare, the petitioner has scored less, 3 marks less for the fourth semester exam. 3 marks less to the pass mark in the fourth semester exam. This stuff. Issue notice returnable by 4 weeks. All the these things are all are represented, all the respondents. 1, 2, 3, 4. Mr.
My lord.
Standing Counsel, Higher Education Department, for respondent number 1, and Bodoland University.
2 and 3, but SC Bodoland University name has not been shown in the cause list.
Yes. And Mr. KKD, then Counsel for respondent 2 and 3.
Of the name of BTC and
Huh?
I request you to stop of the name of BTC. Lordship, we are not a necessary party in this repetition.
Is he? No, BTC is not there. BTC is not there.
When wrongly served copy to them
Yes.
and their name has been shown in the cause list.
It's okay. You are not there. You are not a party.
SC Bodoland
So and
University.
so, no formal notice need be served. Have an extra copy issued, sorry. Have an extra copies be so and so. Then counsel the petitioners to take steps for service of notice upon respondent number 4 within 2 days. This after 4 weeks.
Obliged.
Item 6.
Lordship, my senior AK Bhulia is on legs. I request you to take up the matter after some time.
What is the matter?
In this case, the.
Yes, instruction.
Lordship, Lordship, the file is with my senior. Lordship, the file is with my senior.
Where is?
He is in the trial court, Lordship.
You are supposed to obtain instruction, your senior.
Many councils
Huh?
representing BTC, my lord, he is not the only one, my lord.
Lordship, if you could take up the matter after some time.
After some time. Yes. Tell him. Tell him that get the instruction.
7.
Here, please, lord.
Yes.
Lordship, this matter relates to lordship selection and appointment of assistant teachers in LP schools, lordship. 3 petitioners before your lordship. They have acquired their DLA degree, Diploma in Elementary Education from NIOS, National Institute of Open Schooling, Your Lordship. After observing all formalities, Lordship, they obtained that degree. That degree was, Lordship, by issuing a letter, Lordship, notice to the Government of Assam, declared invalid. That order was challenged by some similarly situated persons. And finally, the Honorable Supreme Court passed an order that may be seen in page 31.
Yes,
Page 31 may be seen, Lord.
31.
Yes, sir.
Hmm.
There are 3, Lord. However, to avoid any confusion, we again clarified that the 18 months diploma obtained by such persons who were in employment as on so and so and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other.
We'll see. What is this impute notices?
Lordship, page 58.
You are challenging this.
Lordship, the Honorable Supreme Court nowhere mentioned that, Lordship, you
Forget about Honorable Supreme Court. You come to your case first. Facts of your case.
That is relevant, Lordship, Supreme Court's order.
Unless we know your case, how
Yes,
can we
yes,
go
sir.
to directly go to the Supreme Court?
Lordship. Page 58.
58 and 59.
58. It is for married.
This is what is the advertisement
Advertisement, Lordship.
for filling up of?
For filling up, Lordship, LP school teachers.
Heard, Mister. Will issue notice. Heard, Mister.
80 Sharma.
80.
80 Sharma.
80.
Sure.
80 Sharma, learned counsel for the petitioners.
Petitioners, 3
Huh.
petitioners.
Agreed by the notice dated 19/11/2025 and 27 notices. 25 19/11/2025 and 27/11/2025. After 4 months. You are coming after 4 months, 5 months.
Yes.
Issued by the Director Elementary Education, Assam, whereby
February month.
the candidates for recruitment of
Notices out.
for
February.
recruitment of regular teachers of LP and UP schools pursuant to the advertisement A and B wide number E573006 page 58, dated 08/01/2025 for filling up the post of what?
LP school assistant
Assistant
for LP
teachers. Whereby the candidates have been directed to submit details of HSSLC examination and national, what is this? NIOS,
National Institute of Open
national
Schools.
NOIS hyphen UDISC. Failing which failing which same would lead to cancellation of the candidature. This writ petition is instituted. Next para. It is the contention of the petitioners that in terms of the submission of NOIOS this UDISC is not a mandatory requirement No, his submission,
Yes, our
mandatory
submission is not a
requirement
mandatory requirement.
as clarified by the Honorable Supreme Court of India in the case of what? In 30, page
Yes,
31,
Yes,
in the case of what?
page 30.
In case of Vishwanath and others versus State of Uttarakhand and others in civil appeal number 7873 of 2023. Mr. Next para. Issue notice returnable by 4 weeks.
Yes.
You are appearing for all. All.
Reference
And
one,
Mr.
and three.
SMPCST Learned Council for the Learned Standing Council, Elementary Education Department, enters appearance to accept notice on behalf of respondent number
the recruitment is already been over, Lordship. So by this,
1, 2, 3. 1, 2, and 3. 1, 2, and 3. Who is 4, 5? And Mr. So and so, Learned Council for appears for you write both their name and then have enters appearance and accept notice on my respondent 1, 2, 3, 4 and 1, 2, 3 and 4. No formal notice will be issued. However, extra copies will be furnished so and so. You have to take steps. Then consent to the petitioners to take steps for respondent number 5. So and so, so and so. That's all. Recruitment is over already. It should be a futile exercise.
that,
Same
I will file affidavit, Lordship.
You file it, what's there? Yes,
The petitioners people lordship are updated research in school. The petitioners before lordship were terminated. They were initially appointed under OBB scheme in Nalbari district, my lord. They were terminated, and later on, my lord, some similarly situated persons approached this noble court, my lord. This noble court has held that, my lord, the termination orders were, my lord.
yes, madam, who is appearing?
Lordship order, lordship will find at page,
In respect of Nalbari,
my lord.
Nalbari,
Same district.
How many
same-
petitioner?
Same select list, my lord. Here, my lord, in this case,
53. 53.
53, my lord.
Yes, madam,
Notice may be issued in the
not
meantime.
notice.
My lord,
Similar relief, he's claiming
so
similar
my lord,
relief.
to take instruction why they were not allowed to
Have you read the file yesterday? Have you gone through the brief yesterday? What instruction you want?
why
You'll only have to see whether the petitions can be given, provided, granted a similar relief. As granted in the earlier writ petitions.
Lord, no, we have to find out whether
Heard, mister?
I say.
I say, learned counsel for the petitioner. The petitioners who were appointed as teachers, what teachers? Assistant
Teacher in ME school, my lord.
assistant teachers in ME schools in the district of Nalbari
My lord.
in the year 2001
One.
and subsequently cancelled their appointments. Claims for similar relief granted to the petitioners in the in WPC. Name of the party, you say, give the name of the party. WPC
5641-2020,
5641-2020,
Kamal Chandra Das and others.
Sundar Das and others.
Kamal Chandra Das,
Kamal Chandra Das
my lord, and others.
and others
State of
by
Assam,
state of Assam within bracket. And 5627.
my lord.
One will be sufficient. One will be, one writ petition will suffice.
This will suffice, my lord, because
Okay.
this is in respect of.
List of- It is the contention of the petitioners that the petitioners are similarly situated with the petitioners in the aforesaid writ petition, aforementioned writ petition, wherein this court has granted relief for reinstatement
My lord.
with consequential benefits by setting aside the cancellation of appointment of the petition of those petitioners. List of the similar mode and method have been adopted while the petitioners, while the petitioners' appointment were cancelled. Next paragraph. Considering the considering above, comma, I'm of the considered view that the petition, the learned, the said respondents to obtain instruction as to whether a similar relief, as the case of the order passed in, judgment order passed in WPC 5641 of 2021, 5641
My lord.
2020 would cover the case of the petition, it would cover the case of the present petitioners. Case of the present petitioners. You obtain instruction. I said, I'm of the accordingly, MS A Das, K Das, Standing Council, learned Standing Council for elementary education to obtain instruction. List of matter after 2 weeks. After 2 weeks.
It's a date, my lord, if possible, my lord.
Give that 2 weeks.
Oblige, my lord.
May I please, your lordship, my lord?
Yes.
Lord, matter pertains to my lord compassionate appointment, my lord. The father of the petitioner, my lord, he died on 6/9/2015, and accordingly, the petitioner had applied on 16th of my lord, March 2016, within time, my lord. Thereafter, my lord, his proposal was forwarded before the district level committee, my lord. I'll take your lordship to my lord, page 29, my lord. For want of vacancy, my lord, the district level committee could not, my lord, consider the case of the petitioner, my lord. And finally, my lord, after 2-3 rounds of litigation before this honorable court, my lord, there is a disposal order, my lord, passed by this honorable court, my lord, in my favor. That your lordship will find at page 38, my lord.
28.
Page 38, 39 is the, my lord, operative portion, my lord. This was disposed of on 29th of May, my lord, 2023, my lord.
Where it is?
Page 39, my lord, operative portion, my lord.
Huh.
In the third paragraph, my lord, saying that, my lord, by virtue of clause 15, my lord, of office memorandum dated 1/6/2015, my lord, my case should be considered by the district level committee. And accordingly, my lord,
Hmm.
my lord, I'll take your lordship to the, my lord, next page 41, my lord.
In view of the above, this was remanding matter district level for fresh consider on merits in the next meeting and consider the case of yes, then?
Thereafter, my lord, the district level committee meeting, my lord, in the meeting, my case was considered, my lord. Page
Then?
42, my lord. Page 42, my lord, my name appears as serial number 1, my lord. Reserved-
Recommended.
Yes,
This
thereafter,
is, district level committee has recommended.
he has recommended.
Yes, then?
But the state level committee has not considered, my lord.
Huh.
Although, my lord, there is a similar direction in one of my case, my lord. Just few days back, my lord. The last election, my lord, the similarly situated candidate, my lord.
Hmm.
Page 43,
Hmm.
the operative portion starts from page 44, my lord. Same, my lord, squarely covers my case. It was disposed of 29th of April, my lord. Again, my lord, there is a direction from this honorable court to consider my case, my lord, in accordance with law by following the clause 15 of Office Memorandum dated 1/6/2015. Recently, my lord. 29 April 2026, my lord. Page 44. my lord. Paragraph 4, 5, 6, 7 are relevant. my lord.
This page 43,
Yes, my lord.
it's the same district,
Same district, my lord. It was, yes, in
same
fact,
DLC,
person, my lord. In
same
fact,
recommendation.
Same recommendation, my lord. In fact, you have
Where is this is Sugrim Prasad.
Sugrim Prasad.
Where is this recommendation? His name appears?
Yes, my lord. His name appears in the same first recommendation, my lord.
Where it is?
Yes. Page, my lord, 29, my lord.
No. Minutes of the district level committee.
If I take your lordship to page 29 for a moment, my lord,
Huh.
the name of the petitioner, present petitioner, and my lord, the order that I have annexed, my lord, the last annexer, Sugrim Prasad.
Huh.
Both of the person's name appears, my lord, page 29. my lord,
Sugrim Prasad, want of vacancy.
Yes.
Yours
Page
is,
29, serial number 8 is my lord Sugrim Prasad.
where is your name?
16 is my lord the present petitioner, Rizal Alam Chaudhary.
16. Want
Page
of
29.
vacancy.
Yes.
Same.
Same reason, my lord. And both the cases where, my lord, the direction was issued by this honorable court to consider the case of the petitioner under clause 15 of Office Memorandum, my lord, dated one.
Where is that order? Same order.
Same, permit. But this has been recently disposed of with the direction before the state level committee, my lord.
No, now you hear this. Minutes of the district, page 41. Where is his name?
My lord, in the page 41, my lord, that is a separate minute, my lord. But in Sugrim Prasad's case, my lord, that was decided in a separate minute, my lord.
By the
Same year.
same DLC.
By the same DLC, my lord.
Where is that?
My lord, that is not annexed, but my lord, that was a separate, my lord, sitting, my lord. Same sitting, my lord. Otherwise, my lord, it is squarely covered. Absolutely same condition, my lord. There are 7, lordship will kindly have a look, page 45, my lord. Page 45, there are 7, my lord. In view of the matter, the writ petition is disposed of by directing the respondent authorities concerned to place the case of the petitioner before the next SLC concerned. For considering his appointment on compassionate basis, the SLC in making such consideration shall also take into account clause 15 of the OM dated 1/6/2015. I am praying for similar direction, my lord, in this case also.
Yes. Same district, same action, same action or inaction.
Your problem is that, my lord, father of the petitioner died in 2015, my lord. Father of the petitioner died in 2015. my
Same
lord.
thing.
He submitted application in 2016, my lord. We have to consider the vacancy of.
No,
of the year of
your
2016, my lord.
vacancy, no vacancy, but there is, this court has directed to consider and DLC has now considered, recommended.
Within that period, my
Pursuant
lord,
to the order of this court, DLC has considered
that, my lord.
and recommended his name. So now it's a SLC to consider.
Yes, my
And
lord.
similar order has been passed by this court saying that since it was a pending, the compulsory family pension will not apply.
Yes, my lord.
His case has to be considered.
Will not apply, my lord.
Huh?
The appointment scheme that has abolished in 2000.
No, that's what I'm saying. That has been taken care of. 43.
Yes,
That's right. Page 43.
yes.
Order of this court. You
Page
have seen it.
Page 43, my lord.
Ah, you have seen
That-
it.
My lord, I have.
Same district, same mode of consideration, action, inaction. Here also there was a direction to considered by the DLC and it was considered and recommended. Same thing.
Same thing.
Then my lord,
Same order.
take up by the SLC that for the
Yes.
period
Ah,
of
that is, it's for
2016.
same order in page 43
Yes,
in other writ petition. Same.
same, my lord.
Rejection was also same. No vacancy. Page 29. Same district, same authority. Now his case has been considered by DLC, recommended to the SLC. SLC has to consider.
Yes.
And you have taken the same ground in page
Yes.
43. That
SLC
in view
only
of the
considered by
new
the-
scheme, compassionate family scheme, pension, compassionate appointment, all this thing.
My lord.
I had a different view, but then since you have not challenged this, I have a different view. But in that case, unnecessarily the litigant will suffer.
Yes,
Same order.
my lord.
Heard, mister?
Z. Ahmad, my lord.
Will dispose it of, huh?
Yes,
Jed Ahmad, learned counsel for the petitioner. And also heard Mr. P. Saikia, learned state counsel for respondent number. Who is 1 and 2?
2, 3, and 5.
Huh?
K does, my lord. 1, 2, 3, and 5.
1, 2, 3, and 5. All are represented. Yes. K Das, sorry, and also heard Mr. MSK Das, learned standing counsel. Elementary education. For respondent 1, 3,
3 and 5.
1, 2, 3, and 5. As well as Mr. P. Sekal and State Council for respondent number 4. Disposed of, huh? Page 43, same one.
Deeply obliged, my lord.
You just write, consider first para, first and the thereafter. Having considered that the similar matter has been disposed of by the division bench of the coordinate bench of this court in WPC so page 43, huh? And as agreed to by learned counsel by the parties, this writ petition is disposed of at the motion itself. Stage itself, huh? Then you write. We'll pass the order.
I'm deeply obliged. Much obliged.
May I please, Your Lordship? This matter relates to non-payment of some area salaries, my lord, during the period from 5th January 2015 to August 2018.
Who are you?
That's why I was appointed as librarian in Moridhal College, Dhemaji, my lord, on compassionate ground. Lordship.
So,
But thereafter, he was paid the regular salary, but since his appointment 5th January 2015 to August 2018,
area salary.
area salary.
Ah.
The notice may be issued by
The heard MS
P. Bora.
learned counsel for the petitioner. Huh? Will issue notice? What's there?
Authority lordship, they have not filed a representation also.
Mhm.
Nothing, they're not approaching the authority first.
Lordship,
Have you requested the authority?
Lordship,
nothing-
there is a communication from the college to the authority to release and they have also submitted the statements of area salary before the concerned authority, my lord.
Person already
have-
convicted lordship, convicted person, is convicted
You
with
can
death
say-
penalty lordship.
Hmm?
He's a convicted person. lordship.
Conviction is another matter. my
That's true
lord.
lordship, but one thing that,
Lordship-
and other thing that they have to approach first the authority lordship. I have
Lordship-
submitted them.
Lordship, may kindly see page number 23 for a moment.
I only,
20?
23.
23.
23. This is
What
the
is there?
communication from the college principal, my lord, to the authority.
Resubmission proposal for area salary of Sri Rintu Sharma.
Time to time, they have submitted, my lord,
Who is this? Principal.
principal.
What could be the reason?
Lordship,
What could be the reason of not accepting your
nothing was taken by the authority, my lord.
issue notice? You see, we'll see. Heard heard MS
P. Bora.
P. Bora, learned counsel for the petitioner. By filing this writ petition, the petitioner has sought for a direction to the respondent authorities. No, claiming, sorry, delete it. Next para. Claiming for arrear salary due to the petitioner for the period from, with the period with
Fif-
effect from
Fifth-
January 2015 to August 2018, comma, this writ petition is instituted, comma, please, comma, please stop, next paragraph. The petitioner, you are still working,
No, my lord.
huh?
I was arrested in a police case, my lord, in 2021. Thereafter, he was
Convicted.
convicted, my lord.
And your service is dismissed,
Lordship.
terminated and dismissed.
Lordship, maybe dismiss, he is convicted for death sentence, my lord.
Death sentence.
Lordship. It's pending, appeal is pending, my lord.
You are in the jail,
Lordship.
huh? The next paragraph. Petitioner was appointed as library bearer in the Moridal College, comma, Demaji in the year 2014 on compassionate ground. List of,
Since 22/8/2021, he was under custody, my lord.
huh?
Since 22/8/2021, he was in custody.
Terminate, when you were terminated?
Lordship,
When you were terminated?
lordship, that,
Dismiss or terminate?
lordship, that instruction I do not have, my lord.
You should have a complete instruction and file the petition. List of, it is the case of the petitioner that the despite discharging its duties for the period from 2000, the 2015 Who has filed this petition?
Lordship, affidavit shown by his uncle.
From January 2015 to August 2018. He has not been paid the salary. List of the petitioner. Next paragraph. It is stated at the burden, the petitioner has been convicted in a criminal case and is no longer in the service. List of, issue notice returnable by 4 weeks. You are appearing for all.
Finance is also there.
Huh?
Finance is also there.
I'm what?
As Mr.
I'm S. Bhuya.
K. Buya.
S. Bhuya.
S. Buya, Learned Standing Council, Higher Education Department is appears and accepts notice on behalf of respondent 1 and 2. No permit notice need be served. No, need be issued. Served in respect of our response. Our extra copies to be furnished to the Learned Council for the respondent. Then counsel for the petitioners to take steps for service of notice upon response 3 and 4.
4 is maybe the registered post principal.
3, have you served the copy
Yes, yes.
to the
4.
finance? Who is the finance?
Yes, only maybe.
Then counsel to take steps for service of notice upon respondent 4 by registered post as well as usual process, as well as by usual during 2 working days. Next paragraph. Then counsel for the petitioner is also very quick to serve the copy of the writ petition to the Learned Standing Council for Finance Department. You served a copy.
Obliged.
My appeal, Lordship, this matter is relating to non-payment of salary, arrear salary, Lordship, for 3 months. The present petitioner were appointed during the year 96, Lordship, and their salary were stopped in 2007, alleging that they were excess appointee beyond the budget allocated post, Lordship. Thereof numerous cases were filed before this court. Finally, their case were, case were considered by the government, accommodating a fresh appointee and saying that, and prospective effect was given from 1/11/2020, saying that they cannot claim the past service rendered by them, Lordship. Kindly see the appointment order, Lordship, fresh appointment at page 13. It is 11% last 3 and the accommodation future.
Page
Page 13,
30.
13. 13, the type could be 11% last para, Lordship. This is one of the petitioner. The accommodation teacher will get the prospective effect from 1/11/20 only, and she cannot claim any benefit whatsoever in respect of past service rendered by him or prior to 1/11/20, Lordship. And
Yes.
these 6 petitioners before your Lordship, and 1, 2, 3 already retired, Lordship. Now our claim is that the arrear salary has not been paid from 1/11/20 to 31 January 2021, these 3 months. And petitioner number 1, 2, and 3 already retired from service.
21 to
Arrear salary 1/11/2020 to 31/1/21.
For 3 months.
1,
1/11/20, 2020
11, 20.
to 31 January 2021.
21.
Yes.
Yes.
This 3 months salary has not been paid, Lordship. Out of 6, petition number 1, 2, and 3 already retired from service. And the proposal was submitted, Lordship, long back. That is page 26, Lordship, on 5/10/24 by the district elimination officer. The entire persons concerned with the district, Lordship, but particularly in our claim, Lordship, these 3 months area salary has not been in connection with these 6 petitioners. Others, I am not concerned, only these petitioners, 3 months area salary has not been paid. Proposal submitted long back, Lordship. In
You were
5/10/24. Petitioner.
You had
number-
work. Have you worked? Have you served during these 3 months?
Yes, Lordship.
Because your appointment order is of 2021,
Yes, Lordship.
30th January.
Yes, Lordship. And 1, 2, 3 already retired, Lordship.
No, it's not a question of retire. How you are entitled, this I'm asking.
Accommodated, Lordship, we are working, Lordship. We
Huh?
are working, Lordship, we are working. That is why our proposal has been signed, Lordship. Kindly see page 26.
See, this is the order is of 2021.
The effect is given from 1/11/20, Lordship. Prospective effect.
No, that's why I'm asking whether you have served in the.
Yes, Lordship, yes.
Huh?
Yes, Lordship.
From where we can say.
Lordship,
So
kindly-
as
Lordship,
these
kindly-
3 months you have served.
Lordship, kindly see page 25 is the letter issued by the director saying that to ask the DO to submit the proposal. Kindly see page 25.
Page
25. This is letter dated 11 September 24 by the
page 20.
25.
Ha.
Director Limited Education to DO, District Elimination Officer, Shivsagar. Subject submission of area salary.
Press
proposal-
area salary proposed as per the prescribed condition
Newly
provided
accommodated
by
charge.
mentioning the specific reason for the claim after proper verification and calculation of month was due and drawn statement along with non-drawn treasury office concerned for the year 2024-25.
Yes, Lordship. Because as the payment was not for, that's why this, for that financial year, they asked, Lordship, thereafter page 26 is the reply by the district elimination officer to director, Lordship. This is the month, showing the month of area salary, kindly see page 26. And the list has been given, and list in my name appeared, kindly see page 27, my name appeared in serial number 335, 36, 36, 95, 118. Kindly see page 26 and 27.
The heard Mr.
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioners. How many petitioners?
6, Lordship.
6. The petitioners who have been appointed as what?
Assistant teacher.
Assistant teacher. Who has been accommodated, not accommodated as assistant teacher. in LP/UP
Yes, sir.
school on purely temporary basis by an order dated, different order, the same order,
Same letter dated, same
by
lordship.
separate orders
It is same.
dated 13/01/2021 with effect from 01/11/2020 are aggrieved by the non-payment of arrear salary
Yes.
for the period from 01/11/2020 to 31/01/2021. List of have approached, have instituted, no, comma, the present petition is instituted, Are you getting? List of, it is the contention of the petitioner that initially they were appointed as assistant
Yes,
teacher
lordship.
in the year
95, 96.
95 to 96. And Mr. Hauber, their services, their appointments were cancelled or what?
The salary was stopped alleging that they are excess appointment, illegal appointing.
However,
Illegal
the-
appointing. Yes.
However, the appointment were not cancelled.
No, lordship.
However, their salaries were stopped in the year 2006.
Yes, lordship.
In the 2006, in the 2007, as the petitioners were found to be it was the appointments of petitioners were alleged to be illegal or irregular, which were subjected to what screening committee list of
Subsequent year to this
recommendation. After the subsequently they were appointed, they were accommodated as assistant teachers
with
in the LP/UP school with effect from 01/11/2020. List of, therefore, the petitioners are entitled to arrear salaries for the period of 3 months with effect from so and so, same 01/11/2025 to 31/01/2021. Issue notice returnable by 4 weeks. As Mr. They're appearing for all. SN, what? PN Sharma, all. London Standing Council, Elementary Education Department. Accept notice, enter appearance and accept notice, and we have all the rest, so no formal notice need be issued. I will extra copies, extra. List after 4 weeks. List the matter after 4 weeks.
Item there.
Yes.
Lordship, the petitioner is a Hindi teacher, lordship, appointed on 2/1/2009. lordship.
Yes.
Lordship, the name of the petitioner was duly recommended by the district level committee. Lordship will get page 29, lordship. A relevant portion, lordship, this is the recommendation made by the district scrutiny committee, Jorhat, lordship. Page 30 is the relevant, lordship. I am serial number 6, lordship. Manoj Kolika, lordship. Graduate teacher Hindi. Lordship, last column, lordship. I am holding the
What is the decision?
decision recommended.
What is the recommendation? Your name has not been recommended.
Recommended by the district committee, Lordship.
Then
Then, Lordship, the state level committee did not recommend my name,
rejected.
rejected,
Where
Lordship.
it is?
Page 32, Lordship.
Ah,
Annex of 5, page 32, Lordship will get
yes.
serial number 1, Susanto Bora. The name of the school is Pochim Chowkat UM Vidyalaya, Lordship.
Susanto Bora.
Lordship, and Obijit Dash, Minu Goswami, and Anjana Bora. This is the 4 teacher whose name have been recommended by the state level committees.
In respect of Pasim Chokat.
Lordship.
Then
Thereafter, Lordship, the service of all the teacher, 4 teachers, have been provincialized by order dated 4th of February 2021, Lordship, by the director. I am left out, Lordship. I, along with one more teacher, Lordship, Orsona Fukun, Lordship, whose service was not.
why your service should be provincialized?
Because I am fulfilling all the criteria, Lordship.
Under what provision?
Under the Act of 2017, Lordship.
Which provision? Particular provision?
Lordship, that is why my name has been recommended by the district committee.
So why the state has not recommended?
Because that is, Lordship. My name has not been appeared in the dais, Lordship.
Ah.
That is the reason for why my name has not been provincialized.
Then
Subsequently, Lordship, I show that this honorable court passed judgment and order holding that the respondent need not insist of having his name captured in the dais data, Lordship. Unlike ME school and ME madrasa, high and higher secondary schools employees need not capture his name in the dais, Lordship. I show, Lordship. And on that basis, Lordship, this honorable court passed order directing the Director of Secondary Education to pass orders within 6 months after having verified his service particulars under Section 4 of the Act of 2017, Lordship. May I show, Lordship, his judgment?
you issue notice, nothing else. At this stage.
But it
Heard,
is-
Mister?
But Lordship.
Heard, Mister?
R. Islam.
Islam Learned Counsel for the petitioner. Agreed by the. No, the petitioner. Who is working as what? Hindi teacher. In what?
Hindi.
Assistant teacher. Within bracket Hindi. No, the petitioner. Was appointed as assistant teacher within bracket Hindi. In which school?
Pochim Chowkat UM Vidyalaya, Lordship.
Huh?
Pochim Chowkat UM Vidyalaya, page 25.
Page 25.
Lordship, is my appointment letter.
Pachim Chowkat. Where is it?
In Jorhat district.
What is UM? We call it
Uchcho Madhyamik Vidyalaya.
Huh?
Uchcho Madhyamik Vidyalaya.
You just said UM, huh? Vidyalaya. In the year 2009. Claims for. No, phrase for direction to the responding authorities for provincialization of his service as Hindi teachers under the provisions of in terms of the what the Assam Provincialization Act, 2017.
Lordship,
17 or 18?
17, Lordship.
2017. Please stop. It is the case of the petitioner that the name of the petitioner was recommended by district, what is this?
Committee, Lordship.
Huh?
District Scrutiny Committee.
District Scrutiny Committee, comma,
Jorhat.
Jorhat. For provincialization of his service as graduate teacher Hindi. To the state level scrutiny committee. Mr. However, the state level scrutiny committee has rejected the case of the petitioner on the ground of his name being not on the ground of his name is not being entered in the DISC list of the petition content, the petition contains that by judgment and order dated 12/04/2023. This honorable court has directed the respondent authorities to consider the similarly situated persons without insisting on appearance of the name of the teachers in the DISE list of. Next one, issue notice returnable by 4 weeks. You are appearing for all.
2, 3, and 5.
Yes, who is for 4? Record their name. Huh? Is so and so, so and so. Enters and appears for respondent number. All the respondents are represented, right? No formal notice needed. However, extra copies be furnished to the learned council for the respondents. So and so. You furnish the copy.
Lordship, may I kindly make an observation that pendency may not be a bar, Lordship. Lordship, I am working still, but I am in starvation, Lordship.
You keep working.
Lordship, I am working, Lordship. Pendency may not be a bar in terms of the earlier.
It's okay, we'll consider what's there. Unnecessary.
Deeply obliged.
That has not troubled the paper and ink. They will not consider.
Obliged.
Item 13.
May I please your lordship? Lordship, petitioner before your lordship, this is second round of litigation, my lordship.
Huh?
Second round of litigation, my lordship.
Yes.
Lordship, petitioner before your lordship is the father of the minor child who has appeared in the class 10 examination of 2025 from CBSE board, my lordship. My lordship, what happened was that in the first mark sheet, my lordship, the son of the petitioner was declared fail in science, my lordship. So he got 13 marks in theory paper. Had he got 15, he would have passed. So they applied for re-evaluation. On re-evaluation, a letter was sent by CBSE stating that mistake letter said, means mistake was admitted, so they have done re-evaluation. While doing re-evaluation, what they have done is that in the second result, they have done given pass mark to this son of the petitioner in science, but has declared the son of the petitioner fail in maths, while re-evaluation for the paper of maths was not even done. So the petitioner approached this honorable court, my lordship. After approaching this honorable court, the honorable court has called for the report and an affidavit was also filed. And thereafter, my lordship, this honorable court has directed not to touch the marks of maths and to do re-evaluation with regard to science subject. So again, a re-evaluation was done. In the third revaluation, my lordship, that was declared, my lordship, the son of the petitioner secured one less mark, he got 14. So 3 revaluation was done with the same subject, 3 different marks was granted. In the first revaluation, he was granted 13, thereafter 15, thereafter 14. The son, the whole 1 year during this process has gone, my lordship. So, my lordship, may I take your lordship for a second to annexure 3, page 21. Annexure 3. My lordship may be pleased to peruse science sub 086. Here, in theory, he got 13, my lordship. So,
Earlier, how much?
no, this is first, my lordship.
First, okay.
He got
13.
13. Had
Yes.
he got 15, he would have passed 13. Then thereafter, my lordship, he have applied for re-evaluation. Page 33, my lordship, for a second. 33. Annexure 6, my lordship may kindly see 086 mistake letter cell in the column. Last, my lordship, last, in the column, my lordship, the last middle portion.
23.
Page 33, annexure 6, they have verification status, they have stated.
33.
Yes, my lordship, page 33, the CBSE. Page 33, annexure 6. Yes, 086 mistake letter set, my lordship seen. So thereafter, my lordship, I take your lordship to the next, the corrected mark sheet, annexure 8, page 36. 8, page 36.
Yes.
In mathematics, he was declared failed.
Again.
Again, he has not applied for revaluation or anything in mathematics. He only applied for evaluation in science. Science, he was declared pass by giving 15 marks. My lordship may kindly see 15. 15.
Science 15.
Yes, he was declared pass. But what they have done, well, they have declared fail in 13, whereas he has not applied for any reevaluation in
Earlier, mathematics, how much?
science.
No, how much mathematics?
15.
15. Now it has come to 13.
13. Without
Swapping.
yes, without doing making any prayer, they did of their own, they declared failure, giving pass marks in science, my lordship.
They have swap.
Yes, my lordship.
Maths and science.
Yes.
Then
Thereafter, my lordship, I approach this honorable court at page, my lordship, annexure 9, page 37. The impugned part of the judgment, my lordship. Page 41. It comes from page 40 and the relevant page 41. So reevaluation was said to be done without passing the marks of maths, as no prayer was made with regard to maths and to my lordship. So then thereafter, my lordship, the third mark sheet, it came at annexure 10, page 42, the impugned mark sheet.
mathematics 15.
Mathematics remains the same since the
Science
concept-
14.
Science 14. So
There's a little improvement.
yes, but 115, if you get, my lordship, the same subject, 3 times, 3 different marks was allotted to this boy.
Now, finally, after
Third
third is final, isn't it? Radin?
is fine.
This is the final.
Fine.
You unfortunately missed by
One
1 mark.
mark.
Can't help it.
But my lordship,
How
my-
there can be evaluation after re-evaluation
my
after
lordship,
re-evaluation.
my submission was that in the second mark sheet, I was declared pass.
This is
then-
now corrected.
Yes, now.
First, you fail
Yes, my lordship.
in science.
Yes,
Second, you made to fail in maths. Right?
by declaring pass in science.
Third, maths remain the same. You passed in maths.
Maths, because they
And there's
corrected
an improvement in the third and final 14.
14. My lordship, yes, my lordship, that's true. But my lordship, my submission is that maths was declared in the third.
It's okay,
because-
no issue.
Because the
Finally,
court-
they have declared it.
No,
15.
because the court directed not to touch the maths marks.
So now this has
yes.
not been tasked.
Yes. So my lordship, my submission was that with regard to 1 person, 3 evaluations are done, my lordship. So my lordship, in the second one, he was declared pass. And then thereafter again, he was declared fail. So my lordship, the records should be called for and then a committee may be formed, because same person, 3 marks cannot be given by 3 different marks to 1 person with regard to the same revision committee. So my lordship, because
See, they have done 3 times evaluation, re-evaluation.
it sometimes reflects my lordship an attitude also, adamant attitude to declare fail. Because my lordship, in the second, There was only prayer.
There is an improvement in the final.
No, my lordship.
1 marks has been increased.
My lordship, my humble submission is that.
Maybe you are unfortunate. Otherwise, see, you cannot claim that I should be.
My lordship,
Otherwise, what's the meaning of having an exams?
my lordship, my submission is that, my lordship, a humble submission in the second, my lordship, second evaluation, my lordship. I was declared pass in science with a vindictive attitude to make me feel they have done something which was not even done, prayed for in maths. Now again they did, and they, for what? And my lordship.
Madam, I'm not.
So my lordship, I'm praying here to.
We'll just
proceed
issue
the
notice.
committee.
We'll just issue notice.
Because my lordship, because a minor child, my
Do-
lordship,
do-
both
do.
1 year going on with regard to evaluation, and they are changing one pass again failed. My
See,
lordship.
we understand, but then what can we do?
My lordship, here this honorable court in many occasions have also even expert committee or some direction. So a committee with regard, because
No, we'll see. We'll issue
Because-
notice, nothing.
these initial results were declared on 13/5/2025. His father is only a driver, private driver. He has been fighting for his son since 1 year. My lordship, may kindly consider certain aspects, and my lordship is short. My lordship, I am not ever, even they have constituted the committee also for evaluation. This
Art.
petition of,
Our MS,
as
Been done,
it's
lordship.
okay. We'll issue notice. You'll see. But then how you can have a different marks in every evaluation?
When, as per CBSE bylaws, we have some rules, lordship. We can give 2 grace mark in each subject.
Did
So
you,
earlier, yes.
did you give the grace mark?
Grace mark. So
In,
earlier
in,
he passed,
in which subject?
we
Ah,
have given the grace mark and fail in maths. After the hearing, honorable court.
how can you reduce the
We have-
marks already obtained?
The judgment itself, the honorable court has explained everything, lordship.
Ah,
In paragraph 5 also.
our MS, we're issuing notice, that's all.
S.C. Burua.
Learned counsel for the petitioner. This is a second round of litigation as regards the evaluation and re-evaluation of the marks of the son of the petitioner in respect of the secondary school examination 2025. List of the son of the petitioner who has scored. What is the first one is where?
Annex 3, page 21, my lordship.
Which is scored 13 marks in science subject had applied for re-evaluation.
In theory, my lord.
Huh?
In theory.
The 13 marks in theory of 13 marks in theory of science subject had applied for re-evaluation. List of on re-evaluation. Second, what is that?
Annex 8, page 36.
36. On re-evaluation, the
Of science subject.
Of
it was shown that the science the petitioner, the son of the petitioner had scored 15 marks in theory of science subject and 13 marks in theory of mathematics, whereas in mathematics the earlier marks shown to have been obtained is 15. Having found the discrepancies in the re-evaluation, the petitioner approached this court by writ petition being WPC 5536 of 2025, which has been disposed of on 03/02/2026. List of, in terms of the direction of this, this court, final re-evaluation, another re-evaluation. Was done whereby the marks in mathematics, marks in theory, marks of mathematics, theory mathematics is shown to be 15, and the science, theory, in theory, science subject is shown 14. Shown to have scored 14 marks. List of, it is the contention of the petitioner. Next para, huh? That every evaluation, the respondent authorities have shown different marks, which clearly indicates the discrepancies, serious discrepancies in respect of the marks of his son, which needs to be, which requests to be, needs to be properly evaluated. List of issue notice returnable by 4 weeks, 3 weeks, 2 weeks. We'll make it 2 weeks. When is the next exam?
Lordship, he has already appeared.
When is the next exam, madam?
Next exam, I'm not.
Next year?
Next,
Might be.
It's already over. It's of
Already over.
2025.
This, if he fails, declares fails, then the re-evaluation, I don't think it's June or July, might be in June, July, if
We'll
re-evaluation.
make it 2 weeks. As Miss M.S. Sorenso, learned counsel for the petition, learned counsel appears for all the respondents. Yes.
4 will be.
Which 4?
4,
Four.
450, my lordship.
It's 1, 2, 3. No formal notice need be served. Extra copies be served. So, the learned counsel for the petitioners to take steps for service of notice upon respondent for registered for said.
That's the upon 4.
Can you produce the record?
That will be.
let me ask the Lordship, because a re-evaluation was done as per this Honorable Court order. After a re-evaluation also, he has failed in science subject.
Second was also re-evaluation, my lordship.
Okay, let them file affidavit.
My lordship, because in the earlier litigation, they have already filed the affidavit, and that affidavit is part of the judgment, my lordship. I think no different reasons. So, my lordship, the records will reveal.
No,
On whether
on the next date,
done, everything Lordship.
on the next date, how can you change the marks
Earlier, we have
every now and
given
then?
the grace mark, Lordship. In the earlier, he has failed in science.
Why you have touched the mathematics?
We have given the marks to maths, so he has passed in maths later.
How can you swap the
That's
marks?
why this honorable.
Is it
court
permissible?
The marks of the.
It's
maths-
literally you have swapped the marks of maths and science.
That's why Lordship, so we later on we have,
You see, if you wanted to, if it's permissible to grant, give grace marks, it has to be on one subject. One evaluation, re-evaluation, you have changed the swapped the marks.
subject, he passed in math subject. And he has prayed for, he filed application for re-evaluation of science subject only.
Then why not? If you have a authority to give grace mark, why only one? Why don't you give 2?
In our affidavit, Lordship.
So after that, you have not explained. See, first 13. So you give him next on re-evaluation 15 by reducing the marks of the mathematics, right?
Not really.
That's why I'm saying it's swap.
Because
You have swap it.
grace mark in one.
Number 2, finally, huh? You said 2 marks,
In one subject, Lordship.
huh?
One subject.
So the mathematics remains the same 15.
Yes. Yes.
Now he has scored 13 in science.
Science.
If grace mark is to be given, why not 2?
He secured 14 now. So
Huh?
one grace mark. So according to her 10 also, I get one more grace mark.
No, that's what I'm saying. So if you have the power to, I mean, give 2 grace mark, why only 1?
We file affidavit, Lordship, I will explain everything in
My
that.
lordship, the records, if it is, I don't.
The standing council, Bora, standing council, and say standing council CBSA to produce the records on the next set.
Now what happened? Evaluation
My
policy.
lordship, the date, my lordship,
Yes.
the date.
There's something wrong, or I am not able to understand.
I will explain everything the next day, Lordship.
Anyway,
Today I have no instructions regarding the re-evaluation, everything.
you have appeared earlier.
I appeared, Lordship, after re-evaluation.
Typing 6.
Lordship, I have received in the morning, my lord.
Hmm.
Petitioner has again been transferred because on his own request, since he was, he has submitted a representation
Hmm.
before the authority is concerned.
Hmm.
So your lordship, he is posted to another school, my lord. The honor to service ever mentioned, teacher utilized at Bagargaon Anchelik High School in view of law and order situation arise in Navodaya High School.
Hmm.
Subsequently, at his own request, his service again utilized at Bilashpur Masuria High School.
Hmm.
Yes, final representation,
Hmm.
lordship, and against whom cases are pending, my lord, POCSO.
Hmm.
Wherever he is posted, lordship, he sent lordship obscene messages to the
My lord,
students
that is not part
concerned.
of record, my lord. That my friend may not submit that, my lord.
Why?
I have the objection because, my lord, this kind of submission may not be made before the court, my lord, without my record, my lord. Without record, my lord.
Your instruction, I can ask for it to submit.
Let that,
Lordship,
let the SMS be brought on record, my lord.
everything I'll bring it on record. New document which I have received, my lord, I'll just, lordship will kindly give me some time.
That Petition has been adjudicated by.
Lordship,
my lord.
it is given by Inspector of School, Chirang District, Kajalga, submission of updated report regarding Amguri PS, case number 23.
Okay,
2023.
will issue notice, you file affidavit.
My
Well,
lord,
issue
I'm
notice.
challenging the, my lord, transfer orders, my lord, because this,
No,
never-
this,
I
you are
never applied
challenging how
transfer-
many transfer orders?
2 transfer orders, my lord.
2 or 3?
We did spend 2 days, my lord.
2 or 3?
2, my lord.
Which one you are
My
agree?
lord, the order dated 27/4/2029,
Huh.
2026 and 29/4/2026, my lord.
Three orders.
Page 38 and page 39, my lord.
What about 26-3?
26/3, my lord, that has not been given up operation because of the, my lord,
Then why you are challenging this?
my lord, perhaps that is not required, my lord.
You have, you have,
Yes,
a,
yes, my lord, that is true.
huh?
But my lord, my present challenge is connection 11 and 12, my lord.
Well, this is a heard Mr. ISAK, learned counsel for the petitioner. The petitioner who is working as, what is a teacher?
He was working as in-charge principal of the, my lord, Navodaya High Secondary School, my lord.
Who has, where is your substantive post?
Assistant teacher, my lord.
Huh?
Assistant teacher, my lord.
Who is the petitioner serving as assistant teacher? In which school?
He was working as, my lord, assistant teacher in Navodaya High Secondary School.
Where it is? Where do you get? Navodaya High School.
High Secondary School, my lord.
High school, higher secondary school.
High Secondary School, my lord.
High school.
Higher Secondary School. my
You
lord.
have said Navodaya High School.
Higher Secondary School. Sorry.
You have written.
Initially, I was appointed in high school, but that has been upgraded, and I was made principal in charge by order dated 29 January 2026, my lord.
It's okay. You are agreed by the transfer of the right.
My lord.
Where it is first transfer?
Transfer is at page 38, my lord.
Ah,
Page 38 and 39, my lord.
38 and 39. Nazrul Islam,
No, my lord, I am Farooq Abdullah Salaman Habib, serial number 2.
present
At
place of
49.
posting.
Because of the representation filed by him before the authority is concerned to place it somewhere else. Accordingly, he has been posted, Lordship. On request, his service was again utilized at Bilashpur Machuria High School. So this matter has become infructuous.
No, it has not. It has nothing to do with it. Page 38 is nothing to do with it.
I did not apply.
Huh?
Come up in my answer, my lord. His own representation.
Bagarkoi answered
Lordship, I
it
have
singly.
page 29-4.
No, agreed by the. No, yeah, serving as assistant teacher in Navodaya Higher Secondary School, Nangal Banga. Which district?
Chirang district.
Chirang district. Is agreed by the at least repeated transfer orders that is 2704/2026 passed by the inspector school, Chirang district circle, Kazalgaon. No, before that you read and 29/0 for 2026 then you just passed by the inspector of school, Chirang district circle, Kazalgaon, from Navodaya Higher Secondary School, Nangal Banga, to Bagargaon Anchalik High School, page 38, and then to Bilaspur
Manchuria High School. My lord.
Manchuria High School. Comma. This writ petition is filed alleging frequent transfers without any public interest and administrative exigencies. Issue notice returnable by 3 weeks. As you are appearing for all, who else are appearing? MSP does, then it's standing council, secondary education. What?
Secondary.
Secondary education. Then it's standing council
Secondary.
for respondent number 1 and 2 and Mr. MS B Buya, then senior counsel for and standing counsel for BTC for respondent number standing counsel BTC for respondent 3, 4 and 5. Eventers appear in Excel notice on all behold, there should no formal notice need is be served. However, extra copies will furnish so and so. Next para, considering and taking note of the fact that the land senior counsel for BTC has received the instruction, comma, on or before next date of listing the respondents to file affidavit in opposition.
It's a date, my lord.
Huh?
Assume kindly fix a date, my lord.
3 weeks, huh?
Of June?
Of that.
May I please, Lordship?
Yes.
Lordship, earlier to this instant petition, prior to this instant petition, earlier petition was withdrawn on some technical ground, Lordship. The dispute in this case is that since there is a two-language teacher, Lordship, we are considered provincialized, Lordship. So the claim of the petitioner is that that he is a social science teacher. So his appointment shall also be considered independently,
You
Lordship.
are also language teacher.
Yes, Lordship. I'm social science teacher.
Which school?
Outly, Abiswa, and
How many teachers have been appointed? Provincialized.
he, Lordship. Page number 30, Lordship.
Where is that provincialization order list? Heard MS so and so learned counsel for the petitioner. The petitioner who has been appointed as assistant teacher at Hotley Habichowa ME School. Which district? Which place?
Golaghat.
Golaghat. Is agreed by the provincialization of the service of the respondent number 6. One Srimati Renumai Saikia, respondent number 6 hearing on the ground that the petitioner had joined the service in the year 1995, whereas respondent number 6 had joined in the year 2000. Christoph, you are in which subject?
I'm social science.
This respondent 6 also social science.
Hindi, in the subject Hindi.
Then how can you claim that? Anybody provincial is social science teacher?
Senior most.
No, there are the 3 subjects. There can be the services can be provincial for 3 subjects only. Anyway, it is the contention of the petitioner that since the petitioner is senior to the respondent number 6, his service ought to have been provincialized in place of respondent number 6 in terms of the provisions of Assam education, provincialization of services of teachers, and reorganization of Education Institution Act 2017. Yes? Issue notice returnable by 4 weeks. You are appearing for all. 1 to 5. Mr. A 1 to 4. Who is 5? Huh?
2 and 3 I am there, my lord, and 5 and 6 are private respondents.
Okay. A Fukan. And State Council, Elementary Education and State Council. Did you permit State Council? Enters appearance on behalf of respondent 1, 2, 3, and 4. No formal notice need be served in respect to above respondent. However, extra copies so and so. Then council for the petitioners to take steps for submission notice among respondent. 5 and 6 were registered first, realized by usual process during 2 working days. Take steps. Extra copies and steps. List after 4 weeks.
Matter pertains to arrears center, my lord. So my lord, notice may issue.
You are?
I'm the petitioner, my lord.
You are working as
Working as an assistant, SMS language teacher. This amount.
the petitioner who is working as assistant teacher.
Yeah, now retired, my lord.
Who was appointed, who
I retired on
had-
31/7/2019.
who had
SMS
served as
language
assistant teacher within bracket, now retired. Bracket close. Is praying for payment of arrear salary amounting to rupees 57,933 with interest at the rate of 9% per annum For the period,
Period, my lord, this is
1-1.
1/1/17 to 31/7/2019.
for the period with effect from 1/1,
2017
2017 to
to 31/7/2019.
31/7,
2019.
2019. Why you have not been paid?
Because this is the lapse of the respondent, my lord.
What lapse?
Because I approached, my lord. I approached.
Why, according to you, what could be the reason?
My lord, this is,
Issue notice returnable by 4 weeks. You are appearing for all.
Number 2, 3, and 4.
As Mr. So-and-so, you Sharma, learned standing counsel.
And respondent number 1.
You are two
I am.
standing counsel
Yes.
of what? Secondary education. Enters appearance and accept notice on behalf of respondent 2, 3, and 4. No formal notice need be served. However, extra copies be furnished to the respondent. Petitioners to take. Where is this finance? Then you write her name also. MS so-and-so and Mr. U Sharma so enters appearance on behalf of respondent 1 to 5. 1 to 4. No formal notice need be served. However, extra copies be furnished to the sir. Yes.
Appointed a tutor in 21 January. He was working as in the private stage.
Hmm.
Then suddenly he continued to get his salary till July 22. But his salary was stopped suddenly. So on inquiry, he could learn that there was a case, High Court case, where stay order was granted. Immediately I appeared in the case below and took steps, and on
Your appointment as
as a
you are working as assistant teacher.
agent teacher below
Huh.
since 21 regularly, January. I received salary till 22 July. Then suddenly salary was stopped, and on inquiry I came to learn that there is a High Court case wherein stay was granted against my appointment.
Hmm.
That pays 12 million, right?
Yes.
This stay order.
It's okay. We'll issue notice.
Yes.
Heard Mr.
Only
D.P.
we'll-
Chally,
I
learned
pray that there should be an interim
senior
order
counsel
directing them
assisted
to
by
pay
Mr.
the
M.
current
S.
salary.
So-and-so, learned counsel for the petitioner. List of next para, the petitioner who is working as assistant teacher
My lord.
within bracket tutor at Satsia Kamar ME Madrasa, Golpara. Press for a direction to release the withheld salary and arrears. List of next para. The petitioner, the service of the petitioner was provincialized. Provincialized and consequently appointed as tutor by an order dated 05/02/2021, against which please stop. The petitioner, the promotion of the petition was challenged by one whom?
By a private respondent, Milan.
Challenged by, he's here.
No, he is not here.
No, challenged by one Siri
Habibur Rahman
Habibur Rahman.
Ahmed.
Habibur
school.
Rahman Ahmed. Page
That I have mentioned at page 5.
14, Hafizur Rahman Ahmed in WPC 6881 of 2021. List of the discord by an order dated 06/09/2024. No. Initially, what is the stay?
11/1/22, my lord.
This court,
Page 12,
by an
next
order
page.
dated 11/01/2022, has stayed the provincialization of the provincialization has directed by an order that is so and so, in the interim has directed that further effect of provincialization of the petitioner be not given to the petitioner until further orders. Thereafter, the writ petition was has been dismissed
6/9/24.
for non-prosecution, vacating the interim order by an order dated 06/09/2024. List of next para. It is the case of the petitioner that since the writ petition has been dismissed and the order not to give effect to the provincialization of the order, the provincial order of the provincialization of the petitioner, comma, the appointment of the petitioner automatically stands revived. It stands revived and therefore is entitled to arrears salary as well as current salary.
Current salary.
Next one. Issue notice returnable by 4 weeks. I think you obtain instruction what's there. If
Yes,
nothing survives, you obtain instruction. All right. Next para. Considering above, learned counsel for the standing counsel,
Standing up.
elementary education, Mr. J. Peg, G. Peg is directed to obtain instruction. This is the matter after 2 weeks.
Right.
If the decks are clear, why
Yes,
unnecessary?
That's all.
17.
May I please, my lord?
Yes.
But here, my lord, the petitioner, my lord, and respondent number 4, my lord, they were initially, my lord, joined as assistant teacher. And thereafter, my lord, in 2017, my lord, the petitioner was promoted to the post of assistant headmaster. And he has been working as such, my lord. And private respondent, my lord, he is still assistant teacher of the school. Now the headmaster has been retired, my lord, and prior to his retirement,
Where is the impugn order?
impugn order, my lord, is 28.
20?
28, my lord.
28. Who is Julas Ali? You are?
Abdul Awal, my lord. Dullah Salih private.
Also read the application so and so and so and so so and so. After exam, second dates. Enlisted teacher named Julas Ahmed Ali received graduate school with on the other day so and so. Abdul Hamid so and so. Graduate school with 2002.
Lordship.
Then in that case, he's senior.
My lord,
Heard Mr.
in between, my lord.
Heard Mr.
R. Ali, my lord.
R. Ali, learned counsel for the petitioner. Next para. Challenge made in this writ petition is to the
In between, my lord,
order
there's a
dated.
promotion, my lord.
Order dated. Huh?
In between, my lord, the petitioner, my lord, he was further promoted to the post of assistant headmaster.
So
So, my lord.
02/05/2026
As-
passed
as
by
per
the
Cadre, my
Director
lord.
Secondary Education, Assam, whereby the respondent number
4.
whereby 13 Julhas Ali Ahmed, assistant teacher,
Lordship.
has been allowed to act as headmaster in charge of the, what is school?
Kadang, my lord.
Huh?
Kadang High School.
Kadang High School, comma, in the, comma, Borpeta. Stuff.
Rule has been applied on 14-2.
So why you are saying?
Rule has been applied here, my lord, 14-2. This is for regular promotion, my lord.
Ah. Then what is the provision for seniority? I mean,
He's the assistant headmaster, my lord. He was
Ah.
once promoted, my lord. So when there is a assistant headmaster, my lord, he's, my lord,
same school.
same school, my lord.
Huh?
Yes, my lord.
What is the next promotion?
Next promotion, headmaster, my lord.
Okay. It is the contention of the petitioner that since the petitioner has been promoted to the post of assistant headmaster, who is which is a feeder post to the headmaster, comma, the order allowing the respondent numbers, what 6, 4?
4, my lord.
Respondent 6 is illegal and contrary to the provisions of the law. Please stop. What is the provision for appointment on seniority? What is the provision that once they
For
it is
regular headmaster, my lord, both, my lord, graduate teacher as well as headmaster are qualified. Having, if they have other qualifications.
then it's not that kid he's ineligible. Anyway, issue notice returnable by
When
4
the
weeks.
assistant headmaster is still there, my lord.
See, there are two. The assistant headmaster is a paid grade, including not only assistant headmaster, the assistant teacher also having the graduate pay scale. So far as this, if both the assistant teacher and assistant headmaster is eligible to be appointed for headmaster, what's wrong? We will have to see the seniority. Issue notice returnable by 4 weeks. As MS, who else are appearing? All. You are appearing for all. You, Sharma? 1, 2, and 3. Okay, 1, 2, and 3. No formal notice need be served. However, extra copies be furnished to so and so. Learned counsel for the petitioners to take a stage for service of notice upon response for barrister for as well. Huh? Same.
Pay scale of the petition is
This-
higher than the graduate exam.
We don't know.
As per
The seniority is counted
No.
on the basis of the from
Date
the
of
day
this-
from the date of
receiving graduates.
granting graduate skill
Okay.
pay. So you are 2022. The respondent for 2001.
in between, the fact has been not considered.
What facts?
Lord, the petition has been promoted, my lord. So from the graduate teacher, he was, my lord, promoted to the assistant.
No issue.
Same.
But equally, the respondent for is also eligible to
For
consider.
regular headmaster.
Huh? If both you are eligible to be considered for regular headmaster, seniority will play as per section 14. All right. What do you want? You want that this order should be stayed?
Yes, my lord.
No. Should I reject it?
No, my lord.
Okay.
Mr. Lordship, this matter asked for the time being. My senior is lagging in the court. My senior is lagging in the court, Lordship.
My lord, the AGA is also in legs in court number 6. The timing, my lord.
It will take time.
The timing, password for timing.
It will take time.
For timing, lordship.
Master. May I please, your lordship?
Yes.
My lord, your lordship, may I kindly peruse the last order, lordship, passed by this honorable court, lordship. There has to be some specific
So
instruction.
the
regarding
letter
the
issued by Director of Visitor. Yes. You, Sharma.
My lord, I have gone through one instruction, lordship, which is available in the file, lordship. Wherein, lordship, it is reflected that the government sought certain information from the director, lordship. That whether they were appointed in the post of graduate or not, lordship. So in reply, lordship, the government director already, lordship, gave the information that they were appointed in the graduate post, lordship. So their grade pay should be graduate, lordship. And
in this regard, that proposal was already sent to the government, Lordship. But the government is not granting approval, Lordship. This is only a case, Lordship. So a specific instruction perhaps or affidavit, because they have taken so many times, Lordship, for filing the affidavit, Lordship.
Regarding that, my lord, I have to take instruction, still instruction is awaited, my lord, here, my lord. So sometime may be granted here.
Now, considering the issue, we have granted you 4 weeks time. Last occasion.
10 days, my lord.
Heard Mr. N.S. Burburi, learned counsel for the petitioner. This court on 01/04/2026 directed, granted 4 weeks time to obtain instruction. However, Mr. U. Sharma, learned counsel, again phrased for another 3 weeks to obtain instruction on the ground that he is yet to receive the instruction. Next para. Considering the nature of the issue involved and the conduct of the parties, the respondent authority. Nature of the issue involved in this case. Granting time again and again for instruction would not serve any purpose. Therefore, as a last chance, Mr. U. Sharma, London Standing Council, Secondary Education, to obtain instruction and file, bring on record by an affidavit. The affidavit as directed herein above shall invariably filed on or before the next date. Else, this court would proceed to decide the matter on its own merit.
Another similar matter, Lordship.
At least after 3 weeks.
Date may kindly, because 22 matter, Lordship. Any date, Lordship.
Give the date.
My lord, another similar matter, Lordship, pending, WPC 1846/2022.
List along with so and so, so and so.
1846/2022. I love that.
Please, Your Lordship.
Yes,
My lord, in this case, I need to file reply, my lord. This
on the
may-
prayer of Mr. So and so, London Council for the petition for the 3 weeks, 2 weeks time is granted to file affidavit in opposition, affidavit in reply. Mr.
M.S. Alam, Lordship.
Huh?
M.S. Alam, for respondent 6, Lordship.
M.K. Sharma.
M.S. Alam, Lordship. M.S. Alam.
M.S.
Yes, Lordship.
M.H.S.
Yes.
Okay.
It may be given, all pending matter, Lordship. Lordship.
After 4 weeks.
Obliged, Lordship.
Highly obliged, Your Lordship. May I please, Your Lordship, this matter is regarding the provincialization of charges. my
Ah.
lord. At
So-
the time of provincialization, my lord, my post was dropped, my lord.
Hmm.
And thereafter, my lord, several proposal was sent, my lord, due to mistake of the, my lord, headmaster of the school, my lord,
Junior assistant.
and my lord, respondent authority, my lord, filed affidavit, my lord, as per stand taken by the respondent, my lord, this matter may be disposed of, my lord.
Huh?
As per stand taken in affidavit in opposition in para 5 and 6, my lord,
Hmm.
my petition may be disposed of, my lord.
Matter may be fixed for admission, lordship, reading is complete.
It's admission only.
It is not admission, my lord. Lordship, in
What
affidavit
does
in
it say?
opposition, my lord,
What does it say?
uh,
Para?
para 5 and para 6, my lord.
Hmm.
Their stand is, my lord.
Someone not prepared this petition, say following on so and so, legal as per the non the proposition was promised as per the provisions.
Para 6, my lord, last paragraph, my lord. Therefore, at this stage, the case of the petitioner can be considered without recommendation of the DLC uh, district level scrutiny committee as well as the state level scrutiny committee, my lord.
They are saying that it cannot be considered without recommendation of
Yes, my
DLC.
lord, the respondent may be directed to place my case before.
It just cannot be like that.
As per new act, my lord.
How can? What is the provision?
Lordship, as per new act, my lord.
What is the specific provision? So what's the specific provision?
Lordship,
Which provision?
I'm entitled, my lord.
Under which provision? Particular
Uh,
provision I'm
my
asking.
lord, under provision, my lord, section, my lord, 4(2) and 4(2) subclause 3, my lord,
Let's see.
of 2000.
Page.
2018, my lord.
Hmm. Hmm. Two 2018. Secondary.
The one from 2017, I have 6 years of continuous service, my lord.
Where it is?
Clause 4(2).
Venture
subclause
is means
3, my lord.
non-teaching, huh? Non-teaching.
Clause 4(2).
Hmm.
Except,
Any non-teaching stuff has been provincialized?
yes, my lord.
Then
Provincialization order is, my lord, on page 17, my lord.
hmm. Junior assistant.
No, my lord, other teaching and non-teaching staff, my lord.
Hmm.
Provincialized page
Page?
17, my lord.
Huh?
Page 17, my lord.
Page 17.
Page 17, my lord. No, I had not.
Headmaster, Hindi teacher, grade 4. Why your case has not been considered?
Lordship, due to mistake done by the head teacher, my lord, in regarding my date of joining, my lord.
Hmm. Date of joining is?
Lordship, kindly see annexure 6, page 20, my lord. Head teacher, my lord, clarify his position, my lord.
When?
On
What is date of
2015,
joining?
date of joining, my lord, 25/6/2010, my lord. In page 20, my lord, may be seen. Annexure 6, my lord.
You cannot. Huh? What is this?
This is, my lord,
Appointment letter following self-aforesaid of the date of appointment. Sumanat. The date of appointment Sumanat was. What is? What does it say? You read that?
Lordship,
And
with-
the honor
with
to
reference
state
to
that
the
while
subject
sending
cited
the
above, I have the
particulars of
honor
the
to
staff.
state that while sending the particulars of staff for provincialization of the school of the school, the date of appointment of Sri Suman Nath was erroring inserted as the.
What is this? You read it properly. What is this?
This is,
What is this?
this
Please
is
read.
Lordship, actual date of as
Don't
the.
skip. The date of appointment of Sri Suman Nath was what?
Suman-
Was? Read it.
With reference to the subject cited above, I have the honor to
Abhaiya.
state that while sending the particulars of staff for provincialization of the school, the date of appointment of Sri Shumon Nath was erroring inserted as the actual date of.
Don't read further. You explain this. What does it mean?
Lordship, this is sent by the headmaster, my lord.
Is it a Russian language or what? Is it English language what? Or Assamese? What is this? You read it
I am
and
reading-
tell us.
And as the actual date of appointment. of
Forget
Sri-
about that. Before that, you explain this. Samarnath was what? This.
This is written by headmaster, my lord.
So, you are relying on these documents.
Yes, my lord.
So, here
Thereafter,
does
my lord,
it say?
Thereafter, my proposal was sent by the.
Not
school
Mr.
inspector,
So
my
and so, learned counsel for the petition. I want to dispose of the matter and you don't want. If you are not cooperative, if you are not giving proper assistance, how can we dispose of the matter?
Ship, I am.
I asked you a simple question. Explain what is this? Sumarnath was what? You read it. Why you are skipping that?
I am not skipping, my lord. Shumon
You
Nath
read
was-
it and tell us what is this?
I think so. Yes, reading. Heroine, so. I don't know. It is.
Have you understood
Yes,
what
my
I'm
lord.
saying? What is this? You read it properly and tell us.
Ship, I am reading whatever he written, my lord, in this.
Since you are relying on documents,
Yes, ma'am.
you have to explain what does it mean.
Maybe this is a spelling mistake, my lord.
What should be the right spelling? Yes, what do you say, madam? Yes, what is your stand?
Lordship, in this regard, we have filed our affidavit and my stand is that Lordship, the Inspector of School Hailakandi, our office has not called for any application from the incumbents under the non-teaching staff category who were dropped in 2013 under the Assam Henshaw Education Institution Provincial Services Act 2011 for taking into consideration of provincialization of non-teaching staff under the provisions of the Assam Education Provincialization of Services of Non-Teaching Staff of the Henshaw Educational Institute Act 2018, for which the case of the petitioner could not be placed before the District Scrutiny Committee for obtaining necessary recommendation. And the case of the petitioner cannot be considered with the recommendation of the District Level Scrutiny Committee as well as by the State Level Scrutiny Committee.
You have read for yourself. I have not understood anything. Explain now.
As lordship,
No, can you consider now? Consider the case of the petitioner. Because his date of joining was appears to be wrongly inserted. So that the headmaster has sought to clarify that, but then what words he has used, we don't know.
headmaster will
Can you consider under the case of the petitioner under section section 4 of the Act? Can you or can you not?
cannot lordship.
Huh? Why?
So we cannot, without any recommendation.
What is the
Lordship.
when the school was recognized? When your school was recognized,
Lordship,
it has to be recognized on or before 01/01/2006.
yes,
If you are
my lord.
relying on section 4.
Yes, my lord, and government also sanctioned the post, my lord, annexure 4, my lord, page 16, my lord. Annexure 4, page 16, my lord, seen, my lord.
Recognized in? Is it before 1/1/2006?
Yes, my lord.
Page?
I have not annexed this, my lord, but page number 16 may be same, my lord. Annexure 4, my lord. Government sanctioned the post, my lord. Junior assistant, my lord, 3 number post was sanctioned, my lord. In serial number 1, my
The
lord.
scale of pay shown against for provincial services of employees the following benches in school housing in the school. Yours is?
Junior assistant, my lord.
No, which is school?
Lordship Polymongol, my lord.
Huh?
Polymongol High School, my lord.
From where do you get it? Madrasa in Hailakandi district, huh? The school name is not given. Is it given?
Lordship, it is only written, my lord, 2-class high school, my lord.
So why you are relying? How do you make out that this is for this school, your school?
It is for the Hailakandi, my lord.
In view of the, due to, this matter is taken up for final disposal. Please, however, due to inability of the learned counsel, Mr. S.B. Leskar, for the petitioner.
H.A. Lashkar.
Huh?
H.A. Lashkar.
H.A. Leskar, learned counsel for the petitioner. Even to place the facts properly, matter could not be disposed of by providing by way of an opportunity to the learned counsel for the petitioner, Mr. Leskar. Let this matter be listed after 6 weeks. In the meantime, learned counsel with the petitioner may prepare the matter, prepare the case, at least, prepare the case, at least, they prepared at least the facts of the matter so that proper assistance could be given to the court. Proper assistance could be provided to the court, at least on the facts, if not on law. Huh? 6 weeks. We want to dispose of the matter. You are not able to place the facts properly also. What is this? 6 weeks. How long you want? 6 weeks. Make it 3 weeks. Huh? Just don't smile. Place your facts properly. Place the facts of the case properly so that we can deliver.
In this case, we have although instruction received, there is not sufficient to file the affidavit.
What is the matter about?
These petitioners are, my lord, assistant librarians, my lord. They are getting lesser pay than that of the, my lord, assistants.
So how you claim parity with this head assistant?
Qualification prescribed is.
Doesn't what? It's not only qualification. What is the nature of the job of you and the head assistant?
My lord, I have been placed in the rule.
Your
my
case
lord.
has been considered.
Placed above the, my lord, head assistants in the rule also, my lord. We have been placed in the above in the head assistants in the rule also, my lord.
What rules?
But
What rules?
my lord, the draft rule. Those will kindly. turn
Just
to page
because
45.
you are getting the same lower pay or grade pay. Grade pay.
Lesser, my lord.
To some lesser pay,
Lesser.
grade pay or
Lesser, my lord.
scale of pay or
Lesser,
grade pay?
lesser scale of pay, my lord.
Scale of pay or grade pay?
Both, my lord.
Both.
Both.
To some with some other post.
My lord.
What is your right?
My lord, the qualification prescribed for the post of head, my lord, the head assistant is high secondary pass. And the qualification prescribed for the post of assistant librarian.
Is it a sine qua non?
My lord, they are getting. Should we kindly turn to page 45 of the schedule.
What schedule?
The rule, my lord.
Rule of what?
From page 34, my lord. Should we kindly turn to page 34, my lord.
30?
34.
Which page you would like to?
Page 34 first, my lord.
Then
34, grade 3-1, assistant librarian,
page 34.
my lord. Those will, under rule 3, my lord. Grade 3-1, assistant librarian, and grade 3-2, head assistant.
Huh?
Grade 3-2 is the head assistant, my lord.
Page
Page
33.
34, my lord. Page 34.
Hmm.
Those is 1496, WPC 1496, my lord.
34. Assistant librarian, grade 3.
Grade 3-1, and grade 3-2 is head assistant.
You are what?
We are the assistant librarians, my lord.
Assistant grade 3. Grade 3, you are grade 3.
Grade 3, my lord. Grade 3. He is also grade 3, my lord. The head assistants, they are placed below us, my lord. They are placed below us in the rule. But getting higher pay than the petitioners, my lord. And schedule loss will find at page 45.
What does it mean? The Assam College Employees Provincialization Rules 2024.
Fine,
Classes and cadre.
my lord.
So, grade T1, grade 2.
Grade 3-1 and grade 3-2.
No. Then
In the schedule loss will find at page 45.
yes.
Assistant librarian.
Schedule of what? This is a schedule of what?
Serial of the rule, my lord.
This rule,
My
provincialization
lord,
rule.
my lord, my lord.
Then?
Serial number 4 is the librarian, my lord.
Hmm.
They are getting scale of pay 14,000 to 70,000 and grade pay is 8,700. And the head assistant, my lord, they are getting 22,000 to 97,000.
So
Grade pay is 10,300.
what's wrong? Are you performing the same duties and responsibility?
My lord.
Are you performing the same duties
we are-
and
we are-
responsibilities?
We are doing, my lord, higher responsibility than the head assistants, my lord.
I don't think so. That will be taken care, that will be examined by the authority.
Qualification prescribed is,
That
my lord.
pay anomaly committee has considered your case. Is not it?
My lord.
Has been considered.
My lord, page 46, Lordship will kindly see, page 46. Assistant librarian, serial number 5, my lord. Bachelor degree in library science. And head assistant undergraduate. Qualification prescribed.
See, degree qualification cannot be only criteria. Unless you show that you perform the same duties and responsibility with the head assistant, or
My lord, post is, my lord,
because your duties and responsibility are completely different.
different.
There's no
My lord, what I am on, my lord, the qualification prescribed is higher than the, my lord,
that cannot be only ground.
head assistants. And my lord,
Not Mr. ISIK
on the last occasion, my lord, this honorable court directed my friend to file the affidavit within 8th of
That's true,
May.
that's true, Lordship,
My
but
lord.
instructions of the
What affidavit is required?
My lord, let the stand of the state be placed before the lordship, so that you can,
Your case has been considered by the pay anomaly committee.
that is under challenge, my lord.
Huh?
That is under challenge, my lord.
We'll accept that.
That is under challenge.
We'll accept that. It has been properly considered. Nothing. Just because you are having a higher education qualification doesn't
Lordship, let the
give you a
affidavit
right
come
to
on-
claim the same
let
pay
the
scale.
Affidavit come on record.
What affidavit?
Yes, sir. This honorable court has already.
Sir, law is very clear. It's not only education qualification. Until the time you show that too, even if you can show that you have the same responsibility and duties and responsibility, even higher,
My lord.
more important. But it is by the authority to
That
determine
we have stated that.
pay
let-
scale, everything. It's
that is
all
what, my lord,
settled.
That is why, my lord, this honorable court.
What is that
directed-
judgment which is against you? Tell us. On the basis why by applying the judgment of the Supreme Court will dismiss.
Lordship, kindly wait for the affidavit.
You know the law or what?
My lord,
You are aware of the law.
let the
I don't
affidavit-
have to tell you.
Let the affidavit be filed, my lord. I am only for.
What difference will make? Definitely
Because
they
we
will
have-
they'll never say that they'll never say that you will be entitled. You will be
We
granted.
have stated that we are doing, my lord, higher duties than the, my lord, higher
Who?
instance.
Who said so?
We have stated in the petition.
Doesn't matter.
They have not controverted that.
Doesn't
my lord.
matter.
They have not controverted that.
You
my
may
lord.
be doing better job, higher, more important, doesn't matter. We'll keep it part hard. We'll allow them to.
My lord.
Huh?
Question keep it part of, my lord. I have no objection.
And Mr. I.S.K. another counsel for the petitioner, who after arguing after arguing the matter at some length submits that respondent authorities may be allowed to file their affidavit in opposition. Affidavit in opposition. Finance has only filed. Okay. It is Mr. B. Gogoi, learned standing counsel or additional advocate general. Additional advocate general submits that affidavit on behalf of the finance department has already been filed.
as we are.
Acceding to the prayer of Mr. I.S.K. learned counsel for the petitioner. Learned counsel for the petitioner. Mr.
Bhuya.
S. Buya, Learned
Higher
Standing Council Elementary,
Higher division.
Higher Education is granted 3 weeks time to file affidavit in opposition.
Okay, fix it, that might be possible.
For dismissal,
But dismiss is also for a local fix it, that matter.
you work, no. You have some research.
Matters pertaining to Kohima bench, admission item 1, review petition 2 of 26.
My please, Your Lordship.
Yes.
Lordship, here I'm yet to receive instructions, Lordship. So if a short date may be given, Lordship.
Is it?
Yes, Lordship.
What is the instruction? Have you received the instruction?
No, Lordship, I have not yet received yet.
You
So
are
if
for,
this,
you're a respondent.
yes, Lordship.
Uh,
Matter
Mr.
can be listed next week, Lordship.
Huh?
If this matter can be listed next week.
Or Mr.
Subhamati.
Subhamati,
Lordship.
Learned Counsel for the review petitioner. Next para. MS. Take the name.
S. Chang.
Huh?
S. Chang.
Learned State Council
Yes, Lordship.
submits that she may be granted a week's time to obtain instruction. Next para. Praise the Lord. List. Praise the Lord. List the matter. After a week.
Lordship.
Hmm.
Much obliged.
Obliged.
1927.
Kindly peruse the last order of this order will put us.
27.
Vice Chancellor.
Yes.
Here, my lord, I need some time, my lord. Petitioner is presently receiving his current salary since 2021, my lord. Regarding his area salary, I need some time, my lord.
Why? Any information? No. Has not been paid.
Because their lordship has passed.
Lord Mr. M. Khan, Learned Counsel for the petitioner. On the prayer of Mr. P.K. Bora, Learned Standing Counsel, Elementary Education. For the 2 weeks time is granted. Another 2 weeks time is granted to obtain instructions as regards the area salary of the petitioner. List after 2 weeks.
It may be given, Lordship.
Give that it.
Obliged.
28.
Affidavit in opposition has not been filed yet, Lordship.
Yes. Yes. You have received the instruction. Heard MS Bidas.
R.
Huh?
R. Dr.
The Learned Counsel for the petitioner. MS SCT, Learned Standing Counsel, Elementary Education. Submits that she has received the instruction which he would like to bring on record by one affidavit. Therefore, praise for listing of after 3 weeks. 3 weeks. Praise the Lord. List after 3 weeks. In the meantime, Learned Standing Counsel to file the affidavit.
29.
My lord, this case relates to the non-payment of pension, my lord,
Hmm.
including my lord provisional pension.
Ah,
On the last occasion, they sought for the time for filing
they have
affidavit.
not filed.
They have not filed, my lord.
Yes.
So I'll pray before your lordship to give my lord interim, my lord,
What
as a
interim?
provisional pension, because I need to survive. I need to survive, man. At least provisional, let them give me.
Affidavit has been sent for vetting, my lord, and it will be filed within 2 days, my lord.
And Mr.
I bought it.
J.I. Burboy, learned counsel for the petitioner, MS. You, Sharma, learned standing counsel, secondary education submits that affidavit has been sent for vetting and therefore, and same will be filed within next 3 days. Therefore, fresh for listing of the matter after 1 week. Within a week,
My lord, let them, date may be
let
fixed,
this,
my lord. Any day next week.
considering above, let this matter listed after 2 weeks,
1 week, my lord, because pension matter.
after 2 weeks,
Date may be fixed.
2 weeks.
Yes,
They'll
ma'am.
file within 1 week, matter will be listed after 2 weeks.
My lord, the date may be fixed.
Keep the date. Yes.
Time being, my lord, senior counsel, Mr. PK also.
What is the matter?
PK also, the senior counsel, he is appear, my lord. Then another, we have already filed our affidavit here, my lord. We have filed reply also, we have filed, my lord. We have filed reply, my lord. They have filed affidavit, we have filed reply. Reply could be finance course. This is.
You have filed the affidavit, reply.
My lord.
Huh?
We have filed, my lord.
Mr.
Do some. Ek other.
A.K. Azhar, learned counsel for the petitioner submits that he has already filed the affidavit in reply. Then what is your?
Oh, we have already filed our affidavit. Okay. And in response to that, they have filed reply. So. We have filed reply 9 to 2026.
As spread by learned counsel for the parties, let this matter be listed after 2 weeks.
My lord,
2 weeks.
issue is very simple, my lord. I have been waiting for such a long period.
Hmm.
Judicial proceeding, I have been allowed to provincialize. There was another writ petition whereby interim order I was stayed. Then, my lord, that writ petition got disposed of by a direction that see the seniority. Ultimately, seniority, it was decided that I am the person who is to be provincialized. In the meantime, that Act of 2011 was declared ultra vires, but I was already provincialized. When they were not doing, I approached this court by a writ petition. A writ petition was decided in my favor, saying that he should be given the provincialization because he was deemed provincialized prior to the act. Then now, after.
Okay, sir, we'll consider after 2 weeks.
Not, my lord, after 2 weeks. My lord, I have been running for this since long, my lord.
You are not working.
I have 59 years, my lord. I will be over.
Are you still working?
My lord, I am 59 years.
Are you still working or not?
Yes, my lord, but I am not provincialized. That is the issue, my lord.
But they're still working.
My lord, I am 59
Yes.
years. Within 1 year, I will be out. Then the case becomes.
After 1 week.
My lord, a date may be fixed, my lord, because.
Next.
If the learned counsel is on leave, then this matter be taken up after some time.
She is asking for the timing.
Time being, lordship.
What time being?
He is on legs, lordship.
Who?
The Upamanya. Pending
Well,
the
it's
state
a
of higher.
case of non-payment of salary. Petitioner herein, he is a physically disabled person who has been appointed in a grade 4 post, my lord. And since his appointment on 1/6/2023, he has not been paid salary. My lord, may I have a look at the last order passed by this honorable court.
After some time.
Provincialization of the service of the writ petitioner, your lordships. She has been working as a language teacher since 1995 till date, your lordships. At the last occasion, this honorable may I draw back to your lordships order dated 26/11/2025, whereby the process has been initiated for provincialization of service of the writ petitioners. But my file has been roaming from one place to another till that no concrete result has been outcome, your
Who
lordships.
said so?
Lordships, order dated.
They filed the affidavit.
Lordship,
Have they filed the affidavit?
No.
Then-
Lordship, kindly go to the order dated 26/11,
Where is 26/11?
26/11/2025.
Huh?
The first prayer, Lordships, MS Tereng P. London Standing Council submits that the relevant file for creation of posts as well as provincialization of the service of the writ petitioner, namely Sipra Mitra of Tengapara High School, Gokras, has already been endorsed to the finance department for necessary approval, and the same is under active consideration of final finance department. See, therefore, seeks some more time to update this code for the same.
Yes.
So, if any updated instruction from the finance department, your lordship will give me 1 week time to get it.
Heard, Mr.
H. Borwa, lordship.
H. Borwalan, counsel for the this court.
On a subsequent occasion, this honorable court has also directed to place the relevant instructions and what is the outcome of the entire thing.
Taking note of the fact that the case of the petitioner has been is under active consideration of the before the finance department for approval. Granted several opportunities to the learned state council to place the up-to-date instruction. When after today again Mr. Kaushik, B. Kaushik Learned Standing Council elimination again praised for a week's time to obtain instruction as allowed by this court on earlier occasions. Instead of considering the fact that the matter is pending for consideration before the finance department as stated by the Learned State Council. That this matter be listed after a week on the next date. Mr. B. Kaushik invariably produce the produce the instruction. Place the instruction.
Date may be fixed, your lordship. Deeply oppressed. 34.
Sorry.
My lord, this is a case relating to non-payment of area of 12 petitioners who were assistant headmaster. Their pay has been fixed from the date of amalgamation of the ME school with high school. They are given the regular pay, but from 1/1/18 to February 22, their pay has not been given yet. They are all retired now and waiting for the thing.
Why you have not been given?
And then
Why they have not been given?
they have not given. Government Council has been asked to take instruction from the department.
My lord, as per my instruction, it is under the consideration of the government, my lord. So sometime may be granted.
And Mr. So and so, Learned Council for the petitioner. Mr. User, Learned Standing Council, Elementary Education, Secondary Education Department submits that the grievance of the petitioners are under active consideration of the government. Therefore, praise for
Time limit may be given, my lord.
praise for 3 weeks time to place the instruction to place the instruction to obtain the instruction.
Follow the instruction already received, my lord. Instruction already received. Only pay order.
Consideration of the government.
My lord.
where it's allowed. List the matter after 3 weeks for placing the instruction.
Any date, my lord?
Give the date.
9 June.
Your challenge is to an order by way of which the petitioner has been asked to refund excess royal, your lordship, after she has already retired from service, your lordship. This is the issue, your lordship.
Affidavit.
Last occasion, they said that they would.
Hmm?
On the last occasion, they said that they would.
Yes.
This is a case which is covered by
Elementary education.
State of Punjab versus Rafiq Masih, which prohibits.
And your lordship, in this case, we have not received any instructions, so sometime maybe another.
And Mr. M.H. Laskar, learned counsel for the petitioner on the prayer of M.S. and Bukhan, learned standing counsel, elementary education department. For that 3 weeks time is granted to file affidavit. 3 weeks.
If a date can be fixed, your lordship. He is not cutting
After
any
3
pension, your lordship, nothing, your lordship. I'll take a date, lordship.
Yes.
Better pertains to lordship, the petitioner participated post of associate professor lordship. Thereafter lordship, they have fulfilled all the eligibility.
What is to be done today? Any affidavit?
No lordship, no affidavit.
What is the challenge here?
Yes, lordship, page 27 is the impugn order lordship.
27.
Yes.
27?
Yes, lordship. 24/7/2024 lordship impugn order is it?
You are selected.
Yes,
You
lordship.
are selected and recommended.
Yes, lordship.
And that has been cancelled.
Yes, lordship, that has been cancelled during the pendency of the another item number 37 lordship. Initially, they have not provided the result lordship. We have selling the sought the result from the respondent authority. Thereafter, during the pendency of this lordship, this order has been passed by the respondent.
My lord,
What is
here
to be
in
done?
Item 36, I appear for the respondent number 2 to 6. However, I have not received copy. And in regard to item 37 and 38, my senior counsel is appearing for the university. In regard of item 36, I have not received copy. Therefore, I couldn't.
There, lordship,
I have
notice is there, lordship. We have already served on
You serve.
10 to 2000.
Heard Mr. So-and-so, learned counsel for deputy. MS. Learned counsel. For respondent 2 to 6 in WPC. 767.
7471.
7471 2025 submits that she has not received the copies of the writ petition for which she could not file the response. Mr. So-and-so, NC Das, London Senior Counsel, assisted by it appears for respondent in WPC
767.
767 and 971.
Actually, in view of this pendency of this new petition, repetition, my lord, these two repetition become infractions, my lord.
Which
Because
one?
the entire selection person that has been satisfied by the executive council, my lord. By resolution, that resolution is now they are challenging, my lord, by filing the present petition, my lord.
This writ petition,
Sir, 767 and
Nine.
971, my lord.
971. So six,
They sought a relief, my lord, for declaration of the
okay. So they have already cancelled. A resolution was adopted.
Yes,
Order
sir.
has been passed.
Yes, Lordship.
So now they put to challenge.
Yes, Lordship.
So this would this become in process.
Yes, Lordship may dispose of the.
Then you write
Lordship-
in item 36 and 37, huh?
Lordship may dispose of with along with this 7471 Lordship. Lordship may keep pending till
Huh?
keep pending this matter, Lordship.
No, no,
subsequent
no. This was only for declaration of result.
Yes, Lordship.
You read separately. No, yeah, the heard Mr. So and so, huh? Could land counsel for the petition. In view of the subsequent action, subsequent development, this writ petition 7471 and 971. 97 has become in process.
767.
767.
767. That is a, huh?
Item 37 and 38.
38 has become in process. And
Lordship,
it become in
this matter-
process.
Lordship.
Become in process. NC Das, London Senior Counsel and so and so. They present, huh? Accordingly, these writ persistence clause of having been become in process. Then we'll just consider on 7471.
Lordship.
Entire
that-
things will be
Yes,
considered.
Lordship, that matter, Lordship, status quo.
So
was
you
already
in that case in 7471 you write
Lordship,
that earlier order.
in that
They
item,
learned
Lordship,
counsel for the petitioner to furnish the copies, requisite copies to the learned counsel for the
Lordship, may I
respondents
submit one thing,
during
Lordship?
the course of the day.
Item number 37 and 38, Lordship, status quo was operating, Lordship. Now, Lordship, respondent authority may phrase advertise for the.
We'll see,
services
we'll
and
see.
popular, Lordship.
The
That's why,
we'll-
Lordship,
we'll- we'll file-
taking
we'll file
this matter
since-
till disposal of this
since
petition, Lordship.
since there was since in view of the order passed, what is that? Interim order. What is the interim order? What is the interim order?
Yes, Lordship, page, Lordship.
One of since I haven't received any copy, I'm afraid that like maybe her place.
Wait for some time till we dispose of the matter. What was the interim order earlier?
Maintain status quo, my lord. That
Maintain
is the
status quo,
interim order,
Lordship.
my lord.
Uh,
That's order.
We'll
dated,
stay, we'll
20
stay, considering that
23, my
the
lord.
action of the respondent in in cancellation of the selection process, selection process.
Selection process, my lord.
Page 26, Lordship, I have an extra order, Lordship.
And a resolution to re-advertise the resolution to re-advertise, comma, till the disposal of the this present writ petition. Status quo be maintained.
Yes,
Habla.
Lordship.
You
Okay.
will file this thing, we'll decide the matter, we'll dispose of the matter.
Lordship, one connected matter is pending, Lordship, WBC number 7.
Why another matter?
Same, similar, Lordship.
Some other person,
Yes, Lordship, subject matter.
list along with so and so.
WBC 7470/25.
Same challenge.
Yes, Lordship, same challenge.
Okay.
Obliged. Yes.
3 weeks. Just wait, we'll finish this. Finish this.
One senior counsel MK Chaudhary sir has not been able to come here. It is some personal reason.
Hmm?
No, my lord, last time also there on the same ground time was taken, my lord. It's a matter of 2020. Now there is a direction by the, my lord, the director of secondary education, higher education, my lord, that the college should send a proposal Now, my lord, it is the principal of the college who has filed the case. What vested interest he has got, my lord?
Who is the principal?
No, my lord, the other writ petition in which
Okay.
they appear.
Principal
Yes,
Silapathar
Silapata.
College.
And
Yes.
there is no governing body resolution also.
What is your challenge in there?
Lord,
Your
yet
case?
What has happened, Silapata College advertised the post of assistant professor in Assamese, my lord.
Hmm.
Now, there initially they selected a person whose selection was turned out to be faulty, my lord. Therefore, this honorable court intervened. Then, my lord, a re-interview was held where I was given second nomination and another person was given first nomination. Now, my lord, I challenged the writ petition. Eventually, the government themselves admitted the mistake that she was given 4 marks on account of one head, my lord, which she is not entitled to, and 2 marks which was due to me was not given. Now, that is the order which has now director has passed. Based on that, my lord, the director has requested the college to send a fresh proposal recommending the name of the petitioner. Now, my lord, the college has filed a writ petition.
They're very
That is the
strict.
locus standi of the principal, my lord. And in the absence of any governing body
College,
resolution.
he's a member of the governing body. No.
Yes, ex officio secretary, principal is the secretary of the governing body.
Okay. How can he file a writ petition?
Lawrence,
How governing body is an aggrieved person, my lord? How can you maintain a writ petition?
personal issue, you could not come to the court, you know.
Personal issue with the principal.
No, Lordship, MK Chaudhary, senior counsel.
We'll take it up on Monday.
Monday, my lord.
Last chance. No further adjournment. This principal appears to be privacy doesn't have locus. How he can be aggrieved with the decision of the government? Okay.
But
Mr. What's your name, please? Learned Counsel appearing on behalf of Mr. M.K. Chaudhary submits that Mr. Learned Senior Counsel for the petition submits that Mr. Chaudhary has some Mr. M.K. Chaudhary Learned Senior Counsel has some his personal difficulty today. Therefore, matters may be listed after 2 weeks on Monday. You just inform Mr. K. N. Chaudhary. Then you write in that in WPC, huh? K. N. Chaudhary Learned as Senior Counsel assisted by so appears for WPC so petition in WPC so as agreed to by Learned Counsel for the parties. Let this matter be listed on to 18.5.
May please, your lordships.
This case, lordship, I need only 1 day accommodation because this case is being handled by one Noyan Khatoni, extending counsel. He is out of station.
May please, your lordships.
Yes.
Lordship, this matter pertains to provincialization of certain teachers. In fact, their claim stands covered by a division bench judgment of this court, of the Gauhati High Court, which has now been affirmed by the Supreme Court also. So be that as it may, I believe today the counter affidavit was filed only today. I don't know whether it's even on record. But a para
Counter affidavit has been filed.
Yes,
today, I believe.
half an hour back.
Okay, so you want some time.
Yes.
Lordship, give us 2 weeks time to respond in
Manish Goswami, Learned Senior Counsel assisted by Mr. R. Singha, Learned Counsel for the petitioner, who submits that the counter affidavit has been filed today, filed and received today only, therefore fresh for some time to file affidavit in reply.
Yes, Lordships.
Mr.
Kindly give us 2 weeks time.
2 weeks time, huh? There's a lot list matter after 2 weeks for filing, so as to enable the petitioners to file affidavit in reply. Yes. After 2 weeks, list after 2 weeks.
Good.
Our instruction is awaited, Lordship.
Heard Mr. R. Malan, Counsel for the petition. On the prayer of Ms. M.S. Swainso,
2 weeks time is
2 weeks time is granted to file affidavit in reply. Yes.
May it pleases your lordship. On the last occasion, your lordship, one question has been asked to your lordship as to whether for the engagement of the petitioner, any finance concurrence is required. And if so required, whether the same was received it or not. Your lordship, one letter has sent by DSA, your lordship seeking that queries your lordship to addressing the commissioner secretary to the government of Assam. And here your lordship reply has received your lordship that there was no concurrence of the finance department at the time of appointment of the petitioner Sajuddin Ahmed. He is a casual employee of office of the inspector of school Walpara. I'd like to furnish the information.
So what is to be done?
Line.
What is to be done?
But he joined his service in the year.
And Mr. You bring on record. You file an affidavit. Have you filed the affidavit? You have not filed affidavit?
No.
Okay. Heard Mr. So-and-so, Learned Counsel for the petitioner. MSP Das, Learned Standing Counsel, Education, Secondary Education Department submits that she has received the instruction which she would like to bring on record by an affidavit. Therefore, first for listing after 3 weeks, prior allowed, list after 3 weeks.
Deeply obliged.
May I please, your worship? Here, my lord, our LO is not given, that is why we have filed a dispute, and appeal was filed. During pendency of this, appeal is allowed by the appellate authority, returning the file to the ERC, that is Eastern Regional Committee, to decide phrase. And some instruction was to us also to be furnished.
You want sometime to obtain
No,
instruction?
not required, my lord. As this appellate authority decided the issue and is sent back to send back. And we have also required documents thereafter we have given. Now it is ERC to decide. That is why lordship may dispose of it.
Saying what?
Observation that as appeal is been allowed and is now pending.
Then it's become infructuous.
No, my lord.
Infructuous.
Infructuous, my lord.
No, infructuous, but
Then it is infructuous, nothing.
no.
Heard Mr.
No, give this
C. Barwa, learned.
no, this during my only one observation is there. The ERC should dispose of the petition at an early date so that we can go for admission.
You request them. What is your prayer in the writ petition?
Yes, that is only prayer.
What is your prayer in the writ petition? If the matter has become infructuous, how can we pass it? How can make an observation? Yes, C. Barwa, learned counsel for the petitioner and also so-and-so. In view of the
Appellate order.
this is ordered by you. Order has been passed or pending. Huh?
Yes, my lord, appellate order is there for your lordship. My lord.
In view of the order passed, in view of the order dated 22/04/2026, passed by the Deputy Secretary, what, within bracket appeal of what?
Last page, my lord, decision is there.
Secretary, National Council for Teachers Education. Whereby the appeal of the appeal has been disposed of, the writ petition became infructuous accordingly.
I am appearing from respondent number 7, your lordship. My name may be
That's
recorded.
right. Accordingly, writ petition states closed as in process.
My lord,
Your lordship, one observation is sufficient, otherwise again I have to come.
Come back.
appellate order.
We'll stop you. You come back.
My lord, that may be part of the record.
The copy of the order dated so and so is kept on record so and so. There's markers there.
Obliged.
Then you will go back. 18.
Back to the-
What is the matter about?
I think area salary lordship
Huh?
for a particular period.
Area salary.
Area salary, my lord. Similar order I have annexed, my lord.
You are working as,
My lord.
you are working as what?
My lord, as a assistant teacher, my lord.
Why teachers are not being paid in the salary in the state of Assam?
Getting the current salary, lordship, as regard the area salary, there will be some.
Current salary that he's getting.
Yes, sir.
Okay. For how many months? Area?
My lord, this is given, my lord, page 20, my lord. Period, my lord.
Mr. So and so learned counsel for the petitioner. As briefed for by Mr. P.N. Sharma, learned standing counsel. Elementary further 3 weeks time is granted to obtain instruction.
Obliged.
4600. Admission is that, sir? Huh? Hmm. SB Chaudhary, huh? 3 weeks.
Lordship, in this case, I'm just praying for some date to be fixed, Lordship, because the
3 weeks, give the date.
pension and pensionary benefits,
Hmm.
Lordship, for us.
Petition 61.
Please, Lordship. Arrear present the respondent sides are directed to submit counter evidence, Lordship.
Lordship, in this matter, I have received my instructions, my lord.
And
I'll be
Mr.
filing my
Director,
affidavit.
Learned Counsel for Mr. A. Pukan, Learned Standing Counsel,
Education.
Elementary Institution submits that he has already received the instruction to which he would like to bring on record by our affidavit. List of therefore praise for listing of the matter after 2 weeks. Praise allowed, list the matter after 2 weeks. In the meantime, the standing counsel to file the affidavit.
That
required
may be
affidavit.
fixed, Lordship. That may be fixed.
Keep that in. Then 3 weeks. Make it 3 weeks.
Obliged, Lordship.
Yes, then I think.
Lord, my part I have completed, my lord. They were supposed to give the reply.
Yes. No, they just before Mr. Sekhar starts,
Yes.
what
My lord-
that,
My lord, what had happened?
no, no, it's okay. That one, which you have relied on that 13 Act,
Yes.
interpretation of 13. Let us just
Yes.
recapitulate
Yeah.
on that.
My lord,
Rest, it's okay. Rest, I
yeah.
remember.
my lord, if your lordship would kindly come to,
2013,
I'll
right
just,
to fair.
please come to, my lord, section 113 of the Act. 13 Act.
113.
Before that, lordship may
Removal of
no, yes, yes.
power to remove
No,
difficulty. Yes.
Before that, my lord will kindly come to section 105.
Hmm.
Provisions of this act not to apply in certain cases or to apply with certain modifications.
Hmm.
Subject to subsection 3, the provisions of this act shall not apply to enactments relating to land acquisition specified in the fourth schedule. That means, my lord, the provisions contained in the Act of 2013 in terms of section 105 will not relate to acquisitions of land by virtue of statute enumerated in fourth schedule. Now, my lord will kindly come to the fourth schedule. In my book, it is page 58.
Yes.
Yes. And you see, there are 13 enactments, my lord.
Hmm.
Serial number 8 is the statute, Petroleum Mineral Pipeline Acquisition of Right of User in Land Act 1962.
Hmm.
So by virtue of section 105, read with fourth schedule of the Act of 2013,
Hmm.
in the normal circumstances, my lord, in acquisitions pertaining to these 13 statutes, provisions of 13 Act will not apply.
Hmm.
However, my lord, now lordship will kindly come to section 1113.
Hmm.
113.
Yes.
If any difficulty arises in giving effect to the provisions of this part, the central government may by order make such provision or give such direction not inconsistent with the provisions of this act as may appear to it to be necessary or expedient for removal of the difficulty, provided that no such power shall be exercised after expiry of a period of 2 years from the commencement of this act. Lord, Act of 2013 came into being on 1st of January 2014.
Yes.
So it says, if any order is passed by the central government whereby difficulties can be removed, it has to be passed within 2 years of the coming into force of the act. That is by Millard on or before 31st of December 2016. Yes, 80. Now, Millard will kindly come to page 80, Millard. Oh, sorry, that book, Millard. That central government has passed an order, Millard. This was passed on 28 August 2015. In
Yes.
my book, it is page 80, Millard.
Page 80.
The right to fair compensation and transparency in acquisition, rehabilitation and resettlement, removal of.
Yes, yes.
Lordship got it, Millard. Now, my lord, after reciting all this, if your lordship would kindly skip over to page 81, first subpara. Now, therefore, in exercise of the power conferred by subsection 1 of section 113 of the right to fair compensation and transparency in land acquisition and rehabilitation and resettlement act 2013, the central government hereby makes the following order to remove the aforesaid difficulties, namely, this order may be called right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, removal of difficulties order 2015. It shall come into force with effect from 1st day of September 2015. The provisions of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 relating to determination of compensation in accordance with the first schedule, rehabilitation and resettlement in accordance with the second schedule, and infrastructure amenities in accordance with the third schedule shall apply to the cases of land acquisition under enactment specified in fourth schedule of the said act. So, my lord, central government in exercise of power under section 113 of the Act of 2013 has passed this order whereby it has been said that the enactments named in fourth schedule in respect of in those enactments, my lord, the provisions of 2013 Act will apply. Now, what had happened, my lord? Now, we were agreed by the compensation which was sought to be paid under that 1962 Act. Our case is no. In view of this, we are entitled to compensation under the 2013 Act. That is the dispute, my lord. Now, the learned, my lord, additional district judge, additional district judge has passed an order saying this order is null and void.
As a what court?
That's I don't know.
No. Additional district judge. As a reference court or
As a reference court, actually, my lord, if we are agreed by any order as per the scheme of 2013 Act, we are to move that court. What provision was that? Section 10. Section P. Petroleum.
under 2013.
Give in, my lord.
Because if you remember,
Yes, my lord.
on the first day I discussed this. This court has raised this issue
Yes,
initially. So we wanted to hear on merit also.
Yes.
But then the kind of the maintainability.
Yes.
That is.
Please come to this Act, my lord, 62 Act, section 18. Huh? So this it is paying. Section? Section 10, subsection. Competent authority মানে court, না? Of course, now, if your lordship should kindly come to me, Lord, subsection 5 of section 10. The market value of the land on the said date shall be determined by the competent authority. And if value so determined by that authority is not acceptable to either of the parties, it shall on application by either of the parties to the district judge as referred in subsection 2 be determined by the district judge. It's something like reference, Miller. Under the 1894 Act, I think it is section 18. Now subsection 2 also may be noticed, Miller. If the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of compensation shall, on application by either of the parties to the district judge within the limit of whose jurisdiction the land or any part thereof is situated, to be determined by the district judge. So, my lord, since we felt that this is not adequate, therefore we move the
District judge.
district judge, and district judge must have referred the matter to additional district judge. Now, the order, my lord.
What is the application? Have you annexed that application?
Yes. That application is at page number 51, my lord. Page 51. And the impugn order is at page 78. Now, if your lordship would kindly come to page number 84, my lord. The first issue which was framed was whether there is a cause of action for filing the petition by the petitioner. Then, my lord, will kindly come to page number 87. The decision of the learned court was, my lord, petitioner does not have the cause of action for filing the petition as such. The issue number 1 is answered in the negative. Then issue number 2, whether petition is maintainable in law or in facts. The answer is that the answer is at page number 103, my lord. Para 60. In view of the above discussion, it is held that petition is not maintainable and thus the issue number 2 is answered in the negative and against the petitioner. The petition is not maintainable. Then, my lord, issue number 3, whether petitioner is entitled to receive compensation in respect of his land calculated under provisions of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act. Now, this I would like to read, my lord. This is where I'll submit, my lord, the learned additional district judge below has, my lord, flawed. The learned counsel for the petitioner has contended that petitioner is entitled to recover compensation as calculated under the Act of 2013. It is pertinent to note that only grievance of the petitioner is that according to the petitioner, the compensation ought to have been determined under Act of 2013 as the central government had by right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, removal of difficulties order 2050, made provisions of the act applicable for determination of the compensation under this particular Act of 1962. However, the Honorable Bombay High Court had in case of so-and-so held that central government had issued the right to so and so, so and so, so and so order without jurisdiction, and hence the same would have no effect. The relevant portion of the above judgment is as follows. In our view, failure on the part of the central government in following the said mandatory provision could not be ratified by issuance of removal of difficulties order by invoking section 113 of the Fair Compensation Act. The removal of difficulties order issued by the central government is without jurisdiction, as the same is issued not for making provision or giving direction not inconsistent with the provisions of the Act, but it is to cover up the default in not issuing a notification in the time prescribed under section 1053. The time prescribed under section 1053 to issue such compensation in the mode and manner prescribed under section 1053 is sacrosanct. In these circumstances, central government could not have exercised power vested under section 113 of the Fair Compensation Act. The central government, under the guise of removal of difficulties, cannot overcome the lapse in not complying with the mandatory provisions prescribed in section 1053. It is therefore seen that the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, removal of difficulties order had been issued by the central government without jurisdiction, and hence the same cannot be enforced. As such, it is held that petitioner is not entitled to calculation of compensation under the Act of 2013. Thus, issue number 3 is answered again in the negative. So, my lord, now, my lord, if your lordship will kindly take the Act, my lord, for a moment. Please come to section 105. Now, this is the reason which has been. Oh, where's it goes? Section 105, Miller.
Yes.
Now, subject to subsection 3, the provisions of this Act shall not apply to the enactment relating to land acquisition specified in the fourth schedule. Very well. Then please come to subsection 3. Central government shall, by notification within 1 year from the date of commencement of this Act, direct that any of the provisions of this Act relating to determination of compensation in accordance with the first schedule and rehabilitation resettlement in the second and third schedule being beneficial to the affected families shall apply to the cases of land acquisition under enactment specified in fourth schedule, or shall apply with such exception and modification that do not reduce the compensation or dilute the provisions of this Act relating to compensation or rehabilitation and resettlement as may be specified in the notification. Now, the learned district judge was of the view, my lord, when section 1053 speaks of 1 year, how come 113 had been invoked? My lord, it is the prerogative of the parliament, my lord. Now, whether there are two provisions, one provision has been invoked. My lord, in fact, this order has been acted upon by the Supreme Court. Yes, there is one Bombay High Court judgment which took this view, but there are other High Court judgments, Supreme Court judgment, where, my lord, the order has been taken to be, my lord, legitimately made. So, my lord, end of the day, it is a central government statute. The best judge is the central government to decide which enactment, if enforced, would be more beneficial to the public, my lord, whose lands are being acquired. And, my lord, where was the occasion on the part of the learned additional district judge below to pronounce on the, my lord, legality or otherwise of the order? Astonishing, my lord. Now, I'll.
Bombay High Court judgment is there.
Yes, it is there. Bombay High Court judgment is there, my lord. Facts are also slightly different. No, before that, I would like to place the Supreme Court judgment, my lord. Bombay High Court is Gangadhar, I have it. Milord will kindly have this Supreme Court judgment, Milord. Asa niki? It was niki 2022 SCC online 1508. Asa mutat ase. 2022 SCC online SC 1508.
Just note it down. Huh? Note it down. Note down, huh?
Please come to para 11, Milord. What were the issues which fell for consideration? Para 11 at page 9.
Yes.
During the course of the hearing, counsel for the parties addressed submission on the following issues. Point number 1, date or dates on which compensation became reckonable. Applicability of the RR Act. Point number 3, 4, and 5, whether RR policy of 2006 applied or subsequent policy of 2013. If later policy of 2013 applied, then for the purpose of employment benefit, whether family unit was deemed to be represented by singular member or several of them, and whether commission could reopen the determinations based on change of policies after its report was accepted. So, basically the issue was whether the benefit of 13 Act can be applied to acquisitions in substance. Then Milord will kindly come to para 19.
Yes.
Consequently, the date fixed in the Gopalpur report by commission, that is September 2000, would be the basis for compensation determination. Apart from compensation, the claimant would also be entitled to statutory benefits, that is solatium, additional compensation in accordance with the Land Acquisition Act, because these events took place before 1/1/14. Now, point number 2, Milord, applicability of the RR Act 2013. Then Milord will kindly come to para 26, Milord. Now, here, Milord, at para 26, Lordships will find the Honorable Supreme Court was referring to 105, where, Milord, 1 year time was given. Then, Milord will kindly come to para 36. In the light of the above discussion, it is held that first schedule of the RR Act 2013 is applicable to acquisition in question made by central government in favor of MCL in respect of villages, the report of which were not approved prior to 28/10/15. Accordingly, compensation based on market value for the 4 villages, so and so, have to be redetermined in accordance with the provisions of the first schedule to the RRA. So here in this case, Milord, the cases which were cleared post 28/10/15, Milord, because that is the date, Milord, when this circular was issued. That Milord, that page 80 notification, Milord, and that was issued on September 28, 2015. Am I clear, Milord?
Yes.
That's why this relevance of this date, Milord. So I am reading that page para 36 once again, Milord, because it's very important in our case. In the light of the above discussion, it is held that first schedule of RR Act is applicable to acquisition in question made by the central government in favor of MCL in respect of villages, report of which were not approved prior to so and so. Accordingly, compensation based upon market value for the 4 villages, the so and so have to be redetermined in accordance with the provisions of the first schedule. So, Milord, in respect of villages where report was not there prior to that, that will be under the old Act of 1894. Then my lord will kindly come to the conclusion at para 70, page 28. Page 28, para 70, my lord, last sentence. Having regard to the following discussion, it is held as follows. Now please come to Roman 2 on the next page, 29, 2.
Yes.
Reference point number 2 on applicability of the RR Act 2013. RR Act came to apply prior to the RR Act cannot apply prior to the date it was brought into force, that is before 1/1/14. In present case, it applies from the date central government issued notification bringing into force the proceedings of the first, second, and third schedule to the enactment specified in the fourth schedule, which in this case was CBA Act. Therefore, on which RR Act 2013 is applicable from 28/8/15. That is the date of the order by which that removal of difficulties order was issued. Additionally, the report which was finalized before that date cannot be interfered with. Landowners and displaced family residing in the villages for which reports were prepared earlier than 28/8/15 would not therefore be entitled to the benefit of RR Act 2013. Hence, the benefit of RR Act apply to displaced families, landowners of so-and-so village. So, my lord, post the date that is 25/8/18, by which the removal order was issued under section 113, from that date, my lord, provisions of the Act will apply. So, my lord, in my humble submission, therefore, the learned additional district judge below was patently wrong, my lord, in forming an opinion based on the Bombay High Court. And there are other High Court judgments, my lord. In any case, my lord, Bombay High Court judgment is having only a persuasive value, my lord. It does not have any binding precedent. My lord, there is one division bench judgment of the Gujarat High Court also, my lord. এখন দেখছো না? না, না। হয়েছে। মই 100 টাকা বুলি কওঁ, চলি আছে। নহলে আমাৰ আৰ্গুমেণ্টটো মানে বেলেগ এটা ডেট ফিক্স কৰি দিয়া হয়। এনে 27 তাৰিখ ল'ব নেকি জুনত? My lord will kindly come to para 22, my lord. Page 20.
Yes.
Now turning our attention to the second contention raised with regard to competent authorities requiring to adjudicate the claim by applying the provisions of Act of 2013 would not detain us for long. Inasmuch as section 105 and more particularly subsection 3 of section 105 make it explicitly clear that enactments specified in fourth schedule of the Act would apply to such exception or modification as may be specified in a notification that would be issued by the central government. The fourth schedule of LR Act has enlisted 13 enactments, and PMP, the same act was in question in this act, as in the present case, my lord, is at serial number 8 under the fourth schedule. Thus, for applying the provisions of Act of 13, central government will have to issue a notification directing that any of the provisions of Act of 13 relating to determination of compensation is in accordance with Schedule 1 and Schedule 2 and 3, being beneficial affected families would apply to the cases of land acquisition under enactment specified in fourth schedule also. It is by virtue of the such power vested, the order has been passed on 28/8/15. The same order, my lord. in exercise of the power under subsection 1 of section 113 of the Act of 2013, bringing within the sweep of determination of compensation under MPM, that is Petroleum Act, same act, by applying the provisions of Act of 13 also. As such, it would needless to say that competent authority would take into consideration this aspect, namely notification dated 28/8/15 issued by the Ministry of Rural Development while determining compensation, and we make it explicitly clear that we have not expressed any opinion and merits of the claim, which is left open to be asked by the respective petitioner before the competent authority. So, my lord, Honorable Gujarat High Court, my lord, in respect of the same Petroleum Act, has taken this view. Now, my lord, I'll refer to two more judgments, my lord, small paragraphs. Yeah. That would, yeah. I do that. My lord, the first judgment on this point is the Nagpur Development Authority's case. That was a case of, my lord, 1970s, where the Honorable Supreme Court says that if there are two acts which can be resorted to by the authority will necessarily like to adopt the statute under which they have to give less compensation. So the Supreme Court said you can't do that. Now please have this, my lord, 2019-9 SCC first. Para 47, 48. Please come to para 48, my lord.
Which one?
My lord, this Tarsem Singh, my lord.
Okay, okay.
It is thus clear that the ordinance as well as the notification have applied the principle contained in Nagpur Improvement Trust, as the central government has considered it necessary to extend the benefit available to landowners generally under 2013 Act to similarly placed landowners whose lands are acquired under section under 13 enactments specified in the fourth schedule. The National Highway Authority being one such enactment. This being the case, it is clear that the government has itself accepted the principle of Nagpur Development Trust would apply to acquisition which take place under National Highway Act, and that solatium and interest would be payable under the Act of 2013 to person whose lands are acquired for the purpose of the National Highway, as they are similarly placed to those landowners whose lands have been acquired for other purposes under Act of 2013. This being the case, it is clear that even government is of the view that it is not possible to discriminate between landowners covered by 2013 Act and landowners covered by National Highway Act when it comes to compensation to be paid for lands acquired under either of the enactments. The judgment delivered under 52 Act as well as Defense of India Act may therefore require a relook in the light of this development. In any case, as has been pointed out herein above, Sajuram has been referred to a larger bench. In this view of the matter, we are of the opinion that the view of the Punjab and Haryana High Court is correct, whereas the view of the Rajasthan High Court is not correct. Now, my lord, what had happened in this case? Now, there were two enactments, the Act of 2013 and National Highway Authority Act. So, my lord, if the land is acquired under National Highway Authorities Act, then the amount of compensation is less. Now, why this removal of difficulty order was issued by central government itself? Because central government felt that it would be beneficial. So, my lord, nobody can sit in wisdom over that. At least, my lord, that order, removal order is not under challenge at the instance of anybody.
That this National Highway Act.
Yes, one of the act included in fourth schedule. Within that 13 Act.
In the act itself,
yes,
it has been incorporated.
Yes.
By now it has been incorporated.
Now it is incorporated. So therefore, my lord, my humble submission is very simple. Now, the learned additional district judge had no occasion to see whether that removal of difficulties order is applicable or inapplicable. Nobody had challenged that. It is not that the learned additional district judge has pronounced upon its invalidity. It is not the case that the learned trial court had declare the act, the order to be null and void. Once it is there, then the provisions will apply. Nobody has challenged that provision. And my lord, when central government itself has issued the removal order under section 13, I am at a loss to find out, my lord, what is the logic which impelled the learned district judge to take this view. Then my lord will kindly take the other act, my lord, other decision, para 7.
Nita Mera.
Yes, para 7, my lord.
Hmm.
Please come to my lord, placitum F. As for future proceedings, has a lordship got it, my lord?
Yes.
Placitum F at para 7.
Yes, yes.
As for the future proceeding, the position would be covered by provision of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, which act has been made applicable to acquisition under National Highway Act 1956 by virtue of notification issued under the provisions of 2013 Act. So here is also a case, my lord, it is referring to that removal of difficulties order. So therefore, my lord, I am entitled to compensation in whatever form it is provided in 2013 Act. So the learned trial court had no business to, my lord, pronounce upon the invalidity or otherwise of the Act. So this is my substance judgment.
What is the appeal provision under this act?
My lord,
Under this Right to Fair Compensation Act 2013, is there any
no,
appeal provision?
no, my lord.
In the reference, after the reference?
There is a provision of reference, as there is a reference, as I have read section 2 of the Petroleum Act, my lord. Here also there is section 64. Supposing, my lord, an acquisition takes place under 2013 Act, then under section 34. In fact, jurisdiction of the civil code has been barred, my lord, under section 63. No, my lord, lawsuit will have the 13 Act.
No, this
Oh, under that
62 Act, there's no provision of appeal.
No. That's in 9. So, my lord, subject to what the other side say, my lord,
Yes.
I reserve my right of reply, my lord. My prima facie, the case which I am trying to project for your lordship's kind consideration is the learned additional district judge below has flawed in, my lord, arriving at a view that this is not applicable, relying on the Bombay High Court judgment.
So this section 74 will not apply of the 2013 Act.
Yes,
No, this is appeal to High Court.
yes.
Okay, this is against the what? Think.
In fact, my lord, Nagpur Development Authority, that is the first case where the Supreme Court took the view that if 2 acts are there, then naturally the government will take advantage. So therefore, it is not that if you acquire a land for a hospital, the compensation would be of a different yardstick. And if you acquire land for government premises, it will be different. No, it's all the same.
That's
So
why
that's the purpose of 2013 Act.
what this order, impugn order has been passed by additional district judge. Will
On
the
a reference.
will the writ petition lie?
Yes.
That
yes.
is
Yes, why not, my lord?
because he has passed
Huh.
as a civil court.
No, lordship will issue a writ of certiorari. Lord, assuming, my lord, appeal is provided, it does not bar your lordship's, my lord.
No, I'm just.
Huh.
Can you make a submission on this?
Yes, my lord. My humble submission.
Why writ petition? This is in order passed by the additional district judge, a
Yes.
civil court.
No,
Because there is a appeal
no, my lord.
under
No,
the CPC.
I'll come to that. No.
Because your application, I understand, is under section the section 10 of 62 Act.
No, my lord.
You can approach the district judge.
No, my lord will
Right.
kindly come to section 63 of the 13 Act.
Yes.
No civil court other than High Court under 226 or 227 shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which collector or authority is empowered by under this Act, and no injunction shall be granted by any court in respect of any such matter. So, my lord, Parliament was of the view that in matters pertaining to this Act, civil court will have no jurisdiction. However, High Court under 226 and 227 has.
No, no, that cannot be ousted. It is a
Yes.
settled position. But
Yes.
what my question is,
Yes, my lord.
you have filed the application
Hmm.
under section 10 of the 62 Act.
No, my lord. Under
62.
74, an appeal would lie against an award.
No, no. You have filed the application before the district judge
Yes.
under section 10 of this
10, 2 and 3.
3 of this Act
Yes.
before the district judge.
Yes.
Once the district judge
Yes.
as a civil court decides, no, just wait. You make your submission. I'm just, formulating a thing. Once the district judge, because the authority is the district judge,
Yes.
it's not in any other capacity or the authority, right? So once the district judge in this matter, in this case, additional district judge has passed and decides the matter following the procedure in a civil suit, in a civil case, will not the appeal under the CPSU will not be applied?
No.
That is what I am.
That will simply no. Why not apply? Please come to section 74 of the 13 Act.
Yes. No, this is not under section 13. I mean, so, it's not, the application was not under, it's not a reference.
No. It was a reference.
No, it's an application under 10 of the 62 Act.
Yes. Under 10 of the 62 Act, no further.
Claiming that the right to fair compensation 2013 Act should be applied.
Yes.
Right?
Yes.
So this is that, but the application was under section 10 or 2(3) of the 62 Act.
Well, there are two ways of looking at it.
Yes.
I have a similar. Other than section 10, there is no further appeal is provided.
Yes.
Therefore, I cannot be remediless.
Yes.
Therefore, 226 will lie.
Yes.
Number one. Number two, my lord, under section 63 of the my lord Act of 2013, a civil court jurisdiction has been barred. But only by way of a reference will lie. Now, against reference, my lord, a 226 petition would lie because under section 63, though civil court jurisdiction has been barred, but the jurisdiction of the High Court under 226 and 227 has been retained. And assuming, my lord,
Just for a moment.
No,
For a minute, I'll just beg to differ. If the reference is made under section 23, any order will be under section 73 only of the 2013 Act. That will be land acquisition, LA appeal. That will be LA appeal.
It's not an award in that sense. This was an order whereby my entitlement itself was
No,
rejected.
not this case. Suppose a reference is made, and if any order on the award or whatever by the reference court, that is authority, under section 63 or 64, the appeal will lie before the High Court as a land acquisition appeal.
Yes.
There's no dispute. But here is, because I've come across for the first time, that's why I'm some reservation that once the application is filed under section 10 of the 62 Act, and if the district judge decides the matter as a civil court, whether the appeal provision, remedy appeal under the CPC will apply or not.
Under 1962 Act,
Yes.
no further appeal is provided.
Yes.
Therefore, 226 will lie.
That is I wanted to know from you, but I have a reservation on it.
Yes.
The
Because 1960.
the form of application, whether
1960
226 or the appeal, appeal under the CPC.
Because under 62 Act, no further remedy is provided, therefore 226 is the only remedy. Technically, my lord.
We'll
it
hear
has-
him also
Yes,
on this
yes.
issue.
Yes,
This is first from the court side.
Certainly.
Whether he has raised this or I don't know, but
Yes, yes. Now they will definitely raise, my lord.
no.
Having got a hand.
They might have pleaded already also.
Deeply obliged. My lord, can I take leave your lordship?
Oh, sure.
I'll come little later. My lord.
Yes, sir.
So far as three major issues I'd like to address, but one is issue, lordship, regarding the 2015 notification,
Yes.
28/9/2015, from which they have developed their arguments today.
This.
Yes, that is not properly pleaded, so
Mhm.
I do not have proper instructions to address on that point.
Achha.
That regarding that notification under section 105 and 113, that 28 September 2015.
Yes.
That acts will also come under the 2013 Act.
Hmm.
Now, let us see their application.
Yes.
Lordship has rightly raised. It is not that as Lordship, it has fallen from Lordship's mouth, but this issue was already addressed by the Honorable Court below.
Okay.
If Lordship is pleased to look at page 51.
51. Their application. Yes.
An application under section 10 of the Petroleum and Mineral Pipelines Acquisition of Rights of Users in Land Act 1962, paying for compensation for acquisition of petitioner's land.
Yes.
So they are asking for compensation.
Yes.
Whether this court has the authority under section 10 of the 1962 Act to determine the compensation. Let us read this provision under the 1962 Act. NMP Act 1962. May I read it, Lordship?
Yes.
Section 10. Section 1. Compensation where in the exercise of power conferred by section 4, section 7 or section 8 by any person, any damage, loss or injury sustained by any person interested in the land under which the pipeline is proposed to be or is being or has been laid, the central government, the state government or the corporation as the case may be, shall be liable to pay compensation to such person for such damage, loss or injury, the amount of which shall be determined by the competent authority in the first instance. So the first instance will determine the compensation.
Yes.
In our case, till now, the amount has not been quantified till date.
It has not been determined.
It is not determined. So
Okay.
if somebody is agreed with the quantum, then they can come and file appeal under section 10. So the competent authority will have to first determine the amount of compensation. If the two, they have filed under 2 and 3. If the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either the parties, the amount of compensation shall, on application by either of the parties to the district judge within the limits of whose jurisdiction the land or any part thereof is situated, be determined by the district judge. So they have come before the district judge under section 10, subsection 2.
2 and 3.
2 and 3.
Yes. Yes.
The competent district judge, while determining the compensation under subsection 1 or subsection 2, as the case may be, shall have due regard to the damage or loss sustained by any persons interested in the land by reasons of removal of trees standing, that is basically JIRAP. 2, temporary severance of lands under which the pipeline has been laid from other land belonging to or in occupation of such. 3, injury or to any other property, whether movable or immovable, or the earnings of such persons caused in any manner, provided that in determining the compensation, no account shall be taken of any structure or other improvements made in the land after the date of notification in subsection 1 of section 3. So the learned district judge has very rightly said that this is a premature case. That is one of the issue framed therein, and the court below has very clearly determined that it is a case of premature, therefore the appeal is not maintainable.
There is no cause of action.
No cause of action has arisen.
So section 2, it goes.
Section 2 goes, please also.
Okay.
This does not come into picture at all.
And section 5 also.
Five,
And
the
at
market value of the
the
land, yes.
petitioner has referred to subsection 5.
The market value of the land of the said on the said date shall be determined by the competent authority, and if the value so determined by that authority is not acceptable to either of the parties, it shall on application by either of the parties to the district judge referred in subsection 2.
This
be
also,
determined by the
this
district judge.
stage is also yet to come.
Yes.
The decision of the district under subsection 2 or subsection 5 shall be final.
Okay.
So this is the position. Therefore, this application which they have filed, without there being a determination of the quantum, they have come for appeal under provisions of section 10(2) and 10(3) of the Petroleum and Minerals Pipeline Act 1962 is not maintainable at all.
What was the stage when his application was filed? What was the stage? Stage of the matter?
The matter because they have.
You said that you said that there was no determination.
The determination.
Only proposal was there.
Further, because this case was from 2020, the
Okay.
acquisition was done in 2019.
Hmm.
And this appeal was filed in 2020. So it is pending because always it was sub judice.
Hmm.
Therefore, the authorities, if Lordship directs, we can quantify the amount.
Ah.
So as because the matter is pending either before the district judge or before this honorable court, the authorities deemed it fit and proper not to proceed any further till the final outcome of this case.
Okay. So what is the procedure under the 62 Act?
Under the procedure is that section 9 is there.
Award has to be passed.
Yeah.
Restriction regarding use of land. How to enter land for inspection. Okay. Section 10. Where in excessive powers conferred section 4(7) or any person loss
Any damage, loss or injury sustained by or any person interested in the land under which the pipeline is proposed to be,
compensation such person for such damage person.
the central government, state government or the corporate case shall be liable to pay compensation for the damage, loss, amount of which shall be determined by the competent authority in the first instance. So we have to go to section 4, 5, 4, 7 and 8. Section 3 is the notification for acquisition.
Yes.
4 is the power to enter and survey. And
Hearing of objection.
hearing of objection.
Declaration.
Basically the same thing.
Hmm.
Only difference with the Land Acquisition Act is that here we do not acquire the land.
Hmm.
We just take the right to use the land,
Hmm.
and it is underneath the soil surface. We lay the pipe and the ownership remains intact with the person of whose the land has been taken for using it as a right of user.
Hmm.
If section 3, may I read subsection 1?
Yes.
Whenever it appears to the central government that it is necessary in the public interest that for the transport of petroleum or any mineral from one locality to another locality, pipelines may be laid by that government or by any state government or corporation, and that for the purpose of laying such pipeline, it is necessary to acquire the right of user in any land under which such pipeline may be laid, it may, by notification in the official gazette, declare its intention to acquire the right of user therein. Every notification under subsection 1 shall give a brief description of the land. The competent authority shall cause the substance of the notification to be published at such place and in such manner as may be prescribed. Competent authority is defined at section 2, subsection A. Competent authority means any person or authority authorized by the central government by notification in official gazette to perform the functions of the competent authority under this act. And the different persons or authorities may be authorized to perform all or any of the functions of the competent authority under this act in the same area or different areas specified in the notification. So now power to enter in survey on issue of a notification under subsection 1 of section 3, it shall be lawful for any person authorized by the central government or by the state government or corporation which proposes to lay pipelines for the transporting of petroleum or any mineral, and his servants and workmen to enter and survey, to dig and bore into the subsoil, to set out the intended line of work, to mark such levels, boundaries line by placing marks and cutting trenches. Where otherwise survey cannot be completed, the level taken and the boundaries and the line marked, to cut down and clear away any part of any standing crop, fence, or jungle, and to do all other acts necessary to ascertain whether pipelines can be laid under the land, provided that while exercising any power under this section, such person or any servant or workman of such person shall cause as little damage or injury as possible of such land. Then hearing of objection is there. Declaration of acquisition of right of user is there, section 6. Then section 7 will be central government or state government or corporation to lay pipelines. Then power to enter and for inspection, etc. Restriction regarding the use of land.
All this has been completed. This procedure has been followed.
Of the cause of action before any court.
That has been followed. No objection, nothing. So only their only grievance is that's 2013 Act has to be applied. Accordingly, they have to be paid.
In 62 Act.
Okay.
Only thing is that whether
What
he
is
has a
the
legal right to do it or not.
What is the determination of compensation under 62 Act? How you determine? It doesn't indicate anything.
In section 10, there is an indication. Subsection 3, section 10, subsection 3.
Education.
The competent authority of district while determining the compensation under subsection 1 or subsection 2 as the case may be, shall have due regard to the damage or loss sustained by any person interested in the land by reasons of removal of trees or standing crop, if any, on the land while exercising the power under section 4, 7, or 8, temporary severance of the land under which the pipeline has been laid from other lands belonging to or in the occupation of such person. 3, any injury to any other property, whether movable or immovable, or the earnings of such persons caused in any manner.
Provided.
But I think the market value will be considered. Maybe there will be some orders or some regulations to that. I can find it out also. Subsection 4 subsection 4 has given the percentage also there.
Yes.
Where the right of user of any land has vested in the central government, state government, or corporation, the central government, the state government, or the corporation, as the case may be, shall, in addition to the compensation, if any, payable under subsection 1, be liable to pay to the owner or any other person whose right of enjoyment in that land has been affected in any manner whatsoever by reasons of such vesting, compensation calculated at 10% of the market value of that land on the date of notification under subsection 1 of section 3. The 5, the market value of the land of the state.
10% of the market value. Apart from the injury or loss caused to the compensation.
Stipulation.
Okay.
How to come to that quantification.
There's no solution, something like that.
Here there is no
perhaps because of the solution only, because market value is already there.
Already there. And 10% is also there.
Yes.
So regarding that quantum, there is no issue.
Yes.
There are two sets of principles. One under 62 Act and the other one is under 2013 Act.
Yes.
Or in Assam, it is 1964 Land Acquisition Act is also there. So only thing is that which act has to be applied. So what will be the quantum as per two different statutes? It is not the subject matter or the list. So now my submission will be that this appeal under section 10, subsection 2 and 3 is not maintainable because it is premature in nature, which is the finding of the learned court below. Also, the district judge also came to the same conclusion, because once the competent authority in the first instance determines the quantum, whether rightly or wrongly, under this act or act may be A or act may be B, or the quantum or quantification, then only the cause of action arises, the door is open.
To approach the district court under 10, 2 and 3, not before
If
that.
they want to get the determination which act has to be applied, they should have come as a writ petition. If they have that thing in dispute. Otherwise, if they have filed it, the district judge has no other options but to follow the provisions as laid down in the statute. So if they are agreed by the learned district judge's order, then they should have come to file a civil revision, not a writ proceedings under 226. That route is not open for them. To that angle, Lordship, I have a judgment of Radheshyam's case. Radheshyam and another versus Sabinath and others, 2015. volume 5 SCC, page 423. Paragraph 27. Does have Lordship found it? Paragraph 27. Page 448. Does we are of the view that judicial orders of civil courts are not amenable to writ of certiorari under Article 226. Very categorical finding. We are also in agreement with the view that referring bench that a writ of mandamus does not lie against a private person not discharging any public duty. Scope of Article 227 is different from Article 226. So the first line is a clincher, Lordship. We are of the view that judicial orders of civil court are not amenable to a writ of certiorari under 226. Their submission at the beginning today is that they are seeking the writ of certiorari to set the order of the district judge. Paragraph 29. Accordingly, we answer the questions referred to as follows. Judicial orders of civil court are not amenable to writ jurisdiction under Article 226 of the Constitution. Jurisdiction under Article 227 is distinct from jurisdiction under 226. Contrary view in Syria Dev Rai is overruled. The matter may now be listed for appropriate bench for further orders.
Okay.
I don't want to take your Lordship to the whole judgment, but this is the final outcome. And it is a full bench judgment. If Lordship is pleased to come to page 423, 1, 2, 3. 3 judges judgment is there. This is one point, Lordship. Another point is that it is premature, then writ petition is not maintainable. And the third point is that notification of 28 September, which is not annexed. So I do not have the occasion to go through that notification. If they want to argue that point, if they pursue with that argument, Lordship, then they must have proper pleadings to that effect and with an annexer. Otherwise, I am totally at dark about that notification. When they were reading it, I have heard it for the first time.
It's published and it is in the book only.
In any case, Lordship, but
2013.
that was not the
I
case.
think the applicability may not
Yes,
be disputed.
The applicability may not be disputed, but what was
But you are-
placed before the district judge? The district judge, the issues, may I place what are the issues framed there?
Yes.
Page 83.
Yes.
Upon the pleadings of the party, learned must take the following issues in this suit. Whether there is a cause of action for filing of the petition by the petitioner. So that is the first. So that in my humble submission, it was premature, which was final outcome. Whether the petition is maintainable in law and or its facts. 3. whether the petitioner is entitled to receive compensation in respect of land calculated under the provisions of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. This is the third issue. And fourth, to what relief parties are entitled. So let us now come to the decisions. On issue number 1, whether there is a cause of action for filing of the petition by the petitioner. The respondents have contended that there is no cause of action for filing the petition and the petition is liable to be rejected. The learned counsel for the petitioner has, however, contended that there is cause of action for filing this petition under section 10 of the PMPA Act of 1942. This is totally in my humble submission, not the tenor of section 10. The learned counsel for the petitioner has contended that section 10 of the PMPA Act of 1962 specifically provides that the aggrieved person can directly approach the district judge having jurisdiction to determine the compensation in case of either of the parties is aggrieved by the determination of the compensation by the competent authority, and thus the petitioner has approached this court directly because it is not satisfied with the manner in which the competent authority was going to determine the compensation. It is seen that it is an admitted fact that the competent authority has not at all determined the compensation in the instant case at hand, and before the competent authority could have determined the compensation, the petitioner approached this court under section 10(2) of the PMPA Act 1962. In my considered opinion, the provisions of the section 10 subsection 2 of PMPA Act of 1962 would be applicable only after the competent authority determines the compensation. But in the instant case at hand, admittedly, the petitioner has approached this court even before the competent authority had determined the compensation under section 10 of the PMPA Act of 1962. As such, in my considered opinion, the instant petition is premature and the petitioner does not have the cause of action for institution of this petition. Section 10 subsection 2 of PMPA Act of 1962 is a special provision and it grants a special jurisdiction to the district judge of the concerned jurisdiction to determine the compensation, if any, of the parties are aggrieved by the determination of the compensation by the competent authority appointed under the PMPA Act of 1962. The PMPA Act of 1962 is a special act dealing with acquisition of right of user in the land, and it specifically provides for the appointment of the competent authority under the PMPA Act of 1962, and the competent authority is entrusted with the power to evaluate the compensation and also to determine the objections, if any, of the parties, and only after the competent authority determines the compensation and any of the parties are aggrieved, then the jurisdiction is conferred upon the district judge of the concerned area to determine fair compensation. In my considered opinion, the petitioner ought to have waited for the competent authority to determine the compensation, and if after such determination by the competent authority, the petitioner finds himself aggrieved, then he ought to have approached this court under section 10(2) of the PMPA Act of 1962 for determination of compensation. Hence, according to me, the above petition is premature and thus the petitioner does not have the cause of action for institution of the instant petition. In view of the above discussion, it is held that the instant petition is premature and the petitioner does not have the cause of action for filing the petition. Decision: the petitioner does not have the cause of action for filing the petition. As such, the issue number 1 is answered in the negative against the petitioner. Number 2, whether the petition is maintainable in law or in facts. The above issue is relating to the maintainability of the petition in its present form. The learned counsel for the petitioner has contended that the petition is maintainable because section 10 of the PMPA Act of 1962 specifically provides that any aggrieved party may approach the district judge having jurisdiction over the acquired land, and thereafter the district judge shall have the jurisdiction in the matter, and as such the petitioner has approached the court. The learned counsel for the respondent company Gale had contended that the instant petition is not maintainable because the petition is filed prematurely and the competent authority has not yet determined the compensation. It is further submitted that the district judge can determine the compensation in case any of the parties agree by the determination of the compensation by the competent authority. However, the petitioner had filed this petition merely to direct the competent authority to determine the compensation by keeping the beneficial provisions of 2013 Act under consideration. Hence, this petition is not maintainable. In order to fully appreciate the dispute between the parties and also determine the various issues in this case, let me briefly narrate the entire scheme of PMPA Act of 1962 and RFCLARR Act 2030, the two major acts which are involved in this case. And skipping this part, finally, the finding is paragraph 32. Paragraph 31. The petitioner has stated by way of this instant petition that the petitioner is aggrieved by the fact that the competent authority has rejected his contention of determining the compensation in accordance with the 2013 Act. Hence, he wants his court to direct the competent authority to determine the compensation in terms of 2013 Act. It is therefore revealed from the prayer made in the instant petition that the petitioner has not approached his court for determination of the compensation, but the petitioner has prayed to direct the competent authority to determine the compensation as per the provisions of RFCLARR Act of 2013. In my considered opinion, the instant petition is not maintainable for the above reason because there is no scope provided in the PMPA Act of 1962 for sending the matter to the competent authority for determination of the compensation in accordance with some set parameters. That is why I said they could have come under 226 in the writ proceedings. The petitioner ought to have waited for the competent authority to determine the compensation, and if thereafter the petitioner was aggrieved, then he ought to have approached the court by way of the instant petition, stating that the grounds and the circumstances which would have entitled him to receive the enhanced compensation, and thereafter prayed before the court to determine the compensation. However, the petitioner has not prayed for determination of the compensation by this court, but has merely stated that the provisions of Act 2013 would be applicable for determination of the market value, hence prayed for directing the competent authority to determine the compensation by taking into consideration the Act 2013. The learned counsel for the petitioner has relied upon the judgment of the Apex Council Court in the case of Union versus Tarsem Singh to show that benefits of Act 2013 shall apply to acquired land under National Highways Act, and further relied upon the judgment of the Apex Court in the case of Mahanadi Coalfield and the case of Gujarat High Court in the case of so and so to show that the instant petition is maintainable as compensation ought to have been calculated in accordance to 2013 Act. I have gone through the said judgments, but the same are not applicable in the facts and circumstances of this case because, as already held above, the petitioner has not filed the instant case for determination of compensation on being agreed by the compensation awarded by the competent authority, but he has prayed to direct the competent authority to assess the compensation as per certain guided parameters, which I already held above to be beyond the scope of PMPA Act of 1962. It is specifically provided in Section 10, subsection 2 of the PMPA Act that the district judge having jurisdiction to determine the compensation in the case. Any of the parties are aggrieved by the compensation determined by the competent authority. Hence, this petition, which prays for directing the competent authority to determine the compensation, is not maintainable as it is beyond the scope of PMPA Act of 1962. The learned counsel for the respondent company has further contended that the petition is bad for non-joinder of necessary parties. It is contended that the competent authority is necessary party, and in his absence, the above petition could not have been decided. It is further submitted by the respondent company that the Union of India is also a necessary party in this case, but the petitioner has not arrayed the Union of India as a party in this case. Hence, the petition is bad for non-joinder of above persons. But in the writ processing present, they have joined the central government. The learned counsel for the petitioner had contended that the competent authority is not a necessary party in this case, because the competent authority has some of the powers of a civil court, hence it is not required to be arrayed as party. Section 2A defines competent authority, paragraph 40 now. The instant case and also it was competent who was to determine the compensation, and the petitioner has prayed to direct the competent authority to determine the compensation as per Act of 2013. As such, it is seen that the competent authority is a necessary party in this case. It is the competent authority who is to initially determine the compensation in this case. Hence, he is the best person to show how he would determine the compensation. The petitioner has challenged the manner in which the competent authority has proposed to calculate the quantum of compensation. Hence, the competent authority was the best person who could have stated how he would determine the quantum of the compensation, and in his absence, I don't think any other person would have sufficiently represented him. Moreover, the petitioner has prayed to direct the competent authority to assess the compensation. As such, any order or direction passed in this case would not be binding upon the competent authority because it is not a party to the petition. Hence, in my considered opinion, the competent authority is a necessary party in this case because of his absence in the instant case.
It's okay, sir. You just come to this page 105 regarding this removal of difficulties.
That was not an issue at
Hmm.
all. The issue number 3, whether the petitioner entitled to receive compensation in respect of his land. Suppose 10 of that notification, if it is applicable, then also the competent authority had to take into consideration, not the district judge.
Therefore, district judge has also erroneously held this. That because of the Bombay High Court, the central government would not have any jurisdiction to issue this notification. It appears to be wrong, may not be go to the root of the matter, but the findings on the applicability of the right to fair compensation in the acquisition under 1962 appears to be erroneous. Just because Bombay High Court has held that.
I fully agree.
Yes.
But at the time of objection, at the time of hearing, for quantifying the amount, at that point of time, all these issues could have been taken. That has not been done. That is why
Who
it
is the competent authority to determine in this case? Where the district collector?
Let me see that notification. This is competent authority. This issue regarding that notification of 2015, that could be placed by the party who has sought compensation.
So basically, what you are saying with your submission is the application itself was not maintainable. Therefore, learned district judge has rightly dismissed the application because it was premature, because no determination was made. But I would, so far as the findings of regarding the applicability, you agree that it appears to be erroneous because you just read. Yes, you just read para 64. Of page 104, that the impugn judgment and order.
Para 64.
Yes.
However, the Bombay High Court had, in the case of so and so, held that the central government had issued the right to fair compensation in land so and so. Removal difficult would have been without jurisdiction, hence the same would have no effect. The relevant portion of the judgment is
this observation.
I do not know what is the subsequent stage of this case. Maybe Supreme Court has some other judgment also. We have not examined this part. That is the open area. Suppose.
So relying on this judgment of the Bombay High Court, what he has was returned a finding in page 60, paragraph 65. Right to fair and so had been issued by Central without jurisdiction, hence the same cannot be enforced as it is held that the petitioner is not entitled to calculation of so and so. Huh.
But that may be incorrect.
Yes.
But that is beyond the scope of the learned district judge also.
Huh.
The district judge may be.
That's why you agree to this point.
I won't make any comments that let that issue be kept open.
Huh.
The competent authority will take a call. They cannot bypass this 2015 order
Huh.
if it is placed at the time of objection.
Huh.
Hearing of objection, that stage is there, section 4 or 5.
Huh.
So when the proceedings will start for determining the compensation,
Hmm.
it will not be determined without hearing them.
Hmm.
On top of that, the person who is before this honorable court, he is one of the 3 owners of the same plot of land.
Huh.
So there may be some other issues also.
Huh.
But this hearing of objection, section 5,
Hmm.
any person interested in the land may within 21 days from the date of notification under so and so object to the laying of the pipelines. Every objection under so and so should be the competently in writing and shall not be set out the ground thereof, and the competent shall give the objectors the opportunity of being heard either in person or by a legal practitioner, and may, after hearing all such objections and after making such further inquiry, if any, as that authority thinks necessary, by order whether allow or disallow the objections. So he has an open forum to raise this objection. But the district judge is not wrong in respect of considering the whole appeal as non-maintainable and premature, because under section 10 subsection 2, that stage has not arisen, has not come. It was an evolving situation. It has not culminated to a particular position which can be challenged. So that is my submission at this stage. I'm keeping that issue open.
Okay.
If there is a notification of 2015, I do not know whether there's subsequent notification to do withdraw. That lot of things can happen also. I do not have any opinion on that.
Now you are also objecting to the maintainability of this writ petition, saying that since the order it's a order of the civil court,
Yes.
either revision or appeal.
Revision, they should have come under civil.
Revision, either revision or appeal. If appeal doesn't lie, should have been a revision.
Then
That is your objection.
Yeah.
That's why I have indicated, because have you pleaded that in your counter affidavit?
Yes.
Okay. Because I have a reservation. Suppose the writ petition is concerned.
No, the writ
That-
petition
that
is not
w-
maintainable at all.
So we'll have to determine that.
Yes, Lordship. Because that will open a floodgate.
Let him.
that will open a floodgate because it is not a solitary case.
I'm not talking about the act, this appeals only in under this act.
But
There
then,
can be
sir,
lot of other
the
acts.
judgment you have relied,
Yes,
this Radheshyam,
yes.
this is out of this matter was a civil suit. Civil suit. This is a application under the application under section 10 of 62 Act, PMPA Act, decided by the civil court.
Civil.
That is a difference. So in under that in the circumstances, whether the 27 or 226 will lie or not, because what the learned senior counsel for the petitioner has said is that since there is no further, provision for appeal under the Act, 226 and 227 will lie. That is what he has said. What he has submitted.
Paragraph. Paragraph 17 of my this ground we have taken.
Okay.
With regard to the statement so and so, the deponent would like to state that the petitioner had not exhausted the alternative efficacious remedy in the instant case as against the judgment order dated 2/1/2024 passed by the learned court below in Miss case so and so, number so and so. Against the same, the petitioner ought to have filed a regular first appeal in the Honorable High Court. Thus, the statement made in paragraph 20 is based on a wrong understanding of law and procedure, and as such, the petitioner is not maintainable under Article 226, which itself is a grave error manifest in the record of the case. In a katana of decision, the Supreme Court has clearly observed that High Courts will ordinarily not entertain a petition under 226 if an effective remedy is available to aggrieved person. To reiterate this, It further observed that it could thus be seen that the High Court will ordinarily not entertain petition under 226 of the Constitution if an effective remedy is available to the aggrieved party. It has been held that this rule applies with the greater rigor in matters involving recovery of taxes, cess, fee, and other types of public money, and the dues of banks and other financial institutions. The court clearly observed that while dealing with the petitions involving challenge to the action taken for recovery of public dues, the High Court must keep in mind that the legislation enacted by Parliament and state legislatures for recovery of such dues are owed unto themselves in as much as they only contain comprehensive procedure for recovery of the dues, but also envisage constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved party. It has been held that though the power of the High Court under 226 are of widest amplitude, still courts cannot be oblivious of, of the rules of self-imposed restraint evolved by this court. The court further held that though the rule of exhaustion of alternative remedy is a rule of discretion, and not one of compulsion, still it is difficult to fathom any reason why the High Court should entertain the petition under Article 226 of the Constitution. Further to add on it, could this thus clearly be seen that the court has carved out certain exceptions when a petition under Article 226 of the Constitution could be entertained in spite of availability of alternative remedies. Some of them are as thus: while the statutory authority has not acted in accordance with the provisions of the enactment in question, when it has acted defiance of the fundamental principles of judicial procedure, it is resorted to invoke the provisions which are repealed when an order has been passed in total violation of the principles of natural justice. It is, however, been clarified that the High Court will not entertain a petition under 226 of the Constitution if an effective alternative remedy is available to the aggrieved person or the statute under which the action complained of has been taken itself contains a mechanism for redressal of grievance. Pausing here for a moment, Lordship. The first cause of action has not arisen till now. So that cause of action has first to be arisen, then the appeal, then thereafter the next course of action. So the first stage has not come. They have jumped to the third stage now. So this is a peculiar situation where they have invoked Article 226 against the order passed by the district judge, and the district judge found that the case is premature in nature.
But one thing, if we upheld this judgment and order of the district judge, there's no scope of application of the 2013 Act or the under determination. Yes, yes.
If the competent authority quantifies the amount
Hmm.
on the basis of a particular act, either 62 or 2000, then he can apply his mind. So I leave this, my position up to focus. My stand is very clear up to this stage. And that issue of 2015 removal order, that can always be taken into account by the competent authority. But not by this honorable court or not by the district judge at this stage.
But the applicability will have to say, because the district judge is wrongly, rightly decides it. They said it will not apply because the Bombay High Court said, and accordingly, the central government doesn't have the jurisdiction to.
Will give me one day to further argue on
Yes.
that point.
I think we'll have to decide because
Yes.
this has been brought on to
But this
issue.
petition is not maintained.
No, that is one part I have heard. That will determine. Hmm.
That this repetition is maintainable.
That will consider because we have already entered
It's a
into
catch 22 situation.
we have already entered into the merit also. We'll decide both the maintainability on the merit also. Yes.
That means lordship has entered in the.
No. We have heard you. First, we'll determine the maintainability. In case
Is maintainable.
maintainable, then we'll decide on the merit. But wrongly or rightly, suppose even if we agree that the petition under application under the section 10(2)(3) of the PMP Act 62 was premature, could not have been filed. But then the observation, as per the removal of difficulties, holding that the central government would not have jurisdiction, it will have an effect until that time we decide the matter.
That in the meantime, I'll ask the competent authority to come to me and take an instruction. What is their opinion on this? I do not know, because they may have some other things also, or they may have faulted also. So let me take that instruction. In a day or two, I cannot do that. Kindly give me 10 days time at least, so that we take a clear stand, and if they are entitled, there is no reasons to deny them.
Because this is one of the important issue.
Concede also that.
Because wrongly or rightly, the observation has been made, findings has been returned. Yes. Yes, that area, once they have decided, we cannot just brush aside. It has to be determined. It has been brought before this court. Yes.
That is giving an opinion regarding the applicability.
Okay, I'll give you 2 weeks.
Lordship. Lordship may make some observations also regarding this.
Yes. Heard Mr. Ken Chaudhary, learned counsel, senior counsel, learned senior counsel assisted by Mr. Learned counsel for the petitioner, and also heard Mr. D. Seke, learned senior counsel assisted by R. Pujari, and so for the respondents. 1 to 5. Who is for Union of India?
We have only for Gale.
Who is for Union of India? Nobody. Okay, we'll see. Argument advanced when the argument from both the sides are almost completed, almost completed, are complete, except on the point of power to remove difficulties under section 113 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013. As the learned additional district judge. Which district? Additional district judge. Barpeta in the impugned judgment order has held that the central government would not have jurisdiction has held that central government, the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement within bracket, removal of difficulties bracket order 2015 has been issued by the central government without jurisdiction. Please stuff. Next page. Considering the importance of the point as decided by the learned additional district judge, this court deem it appropriate to hear the issue list of accordingly. as spread for by learned senior counsel Mr. Disekia for the respondent. A week's time, the matter may be listed after 2 weeks as a part heard. After 2 weeks, you just fix the date.
Could it be on either 2nd or 4th June?
Just show me this. Madam, show me this. Then show me this.
3rd June also. That's a miscellaneous day.
I'll be here, no? 3rd. 2nd or 3rd? 3rd. We'll complete on that day. Ah. No, I find
Only
it needs to be determined. Ah. Better remains part heard, huh? You just compile this, huh? Along with this note. Huh?
10:32. Item 32.
Yes.
Order has already been issued by the Directorate Lordship for appointing him at the Mandya Anchalik College Lordship.
Huh?
There is an order Lordship passed by the Director of Higher Education
Yes.
by thereby appointing this petitioner as Chokidar in the Mandya Anchalik College Lordship, Barpeta. And thereafter, Lordship, his arrear will be processed, Lordship. So since but Lordship, to my telephonic instruction, the petitioner has not yet joined his post. This order is of 5th of May, Lordship.
Yes.
He has not joined the post. Let her have the instruction, Lord.
What is the prayer here?
This is relating to salary, release of salary.
Huh.
He was appointed on 1/6/2023 and he joined in MC College, Borpeta. And since the date of joining, till date, nothing has been paid.
See, you have been appointed in some other college because the college where
During pendency of this.
you were
proceeding.
appointed, just
Yes.
wait. There's no sanction post. And it says that for the release of there's just an appointed the post of so-and-so, Barpeta, against an existing vacant post under so-and-so for release of his salary and pending arrears. Nothing remains. Do you agree with this? This is of 5th of May.
I do not know. I just received this.
Lordship, a copy has been served to.
We'll close the matter. You do whatever. You have not received.
My lord,
How it's possible?
Number 7, Lordship, copy has been served.
Person concerned, Hemen Das.
my lord,
Today is what? Today is what?
Today is 13th, Lordship.
13th.
Read it. See, no, they are not disputing. For your betterment only, for your welfare only, they have doing it.
My lord, my prayer is that
Your prayer is for payment of salary.
payment of salary.
Well, there is no sanction post, how the salary will be paid? So they are not washing you out. They have reappointed you in a college where sanction post is there. It's a chokidar only, grade 4 post.
Grade 4 post.
For release of his salary and pending arrears. You read this?
My lord, we fix this matter.
No,
after
we're
1 week.
disposing of the matter.
My lord,
Unnecessary.
Difficulty is that.
This is unnecessary. Are you disputing this order?
I am This pretty much
Then
I
the
should
copy has been
communicate.
given to you.
But I just want to communicate with the client, my lord. He's a physically disabled person. It's very difficult to communicate with him. He's a deaf person, my lord. I need an interpreter every time I talk to him. But just give me 1 week time. I'll have a talk with him and lordship may.
We'll take it up on Friday. By today or tomorrow, you discuss with him.
Next Monday, my lord. Next month.
Not Mr. So-and-so, learned counsel for the petitioner. Mr. D. Upamani, learned counsel, learned standing counsel, higher education department. By placing the copy of the order dated 05/05/2026, passed by the Director of Higher Education, Assam, submits that the petitioner has been appointed to the post of grade 4 within bracket Chowkidar at Mandia Anchalik College, Barpeta, against an existing vacant grade 4 post. Instead of MC College, Barpeta, as the petitioner, as the petitioner, as the post of grade 4 in which the petitioner appointed at the said MC College no, you just as there is no sanction post at MC College, Barpeta. The copy of the appointment order has already been forwarded, marked to the petitioner. List of. No, you just before that, huh? Copy before copy, huh? Copy option. And for release of his salary and pending arrears, huh? Then you said the copy of the appointment order has already been marked to the petitioner. Next para. Mr. So-and-so, learned counsel for the petitioner, submits that since the petitioner is a disabled person, no, submits that he has not received any instruction. And since the petitioner is disabled person, it is hard to obtain the instruction easily. Therefore, fresh for a week's time to obtain the instruction. Mr. Considering about considering that the petitioner has been appointed in the same appointed by adjustment in a grade 4 post within bracket Chowkidar at Mandila Anchalik College. As the post under which the petitioner initially appointed at MC College. No, as there is no sanction post at MC College, Barpeta, where the petitioner was initially appointed. I am of the prime view that the matter has become infructuous. Matter has become infructuous. Mr. However, as prayed for by learned counsel for the petitioner, let this matter be listed after a week so as to obtain instruction from the petitioner. List accordingly. I've observed that prime view it has become infructuous. Your claim is for arrears and salary only.
Arrears salary.
They have clearly given. The copy of the order so and so 5/5/2026 is kept on record and marked as
If my lord salary is
document.
released, I don't have any grievance.
No, appointed.
Ma'am, of it.
5 बजे तक बैठना पड़ेगा ना, हैं? 5 बजे तक बैठना पड़ेगा ना? Yes.
Submitted the pro rata pension, that proposal to before the.
You bring on record, or has it been complied with?
That Assam with the respondent one has to comply, Lordship.
You are for, who is for one?
I am.
Huh?
11 pass.
So it's between you and your officer. Anyway, heard, Mr. Then counsel for the petitioner. Mr. SM on the prayer, Mr. SMT60, learned counsel for learned counsel. And Mr. Who else are there? MS so and so. Learned counsel for the Alice Contempt nurse. Let this matter be listed or listed after 2 weeks so as to enable this. Please. In the meantime, the Alice Contempt may file their respective affidavit.
It may be picked.
After 2 weeks. Yes, next.
48 Lordship, I need some accommodation, Lordship.
Yes.
Last year,
On the
my
trail of
friend has
Bahar,
submitted one
Mr.
complaint
M.
for the
Khan,
one-
M.
on that
Khan,
we
learned
need some
counsel for the
clarification.
petitioner. It's 2020. Spending since 20. What?
Order, but my learned friend has objected to that. So on that, I need some clarification to get, Lordship. Otherwise, we have submitted a compliance order.
That is not the.
And Mr. M. Khan, learned counsel for the petitioner. As prayed for by Mr. SMT60, learned counsel for the Alice Contempt. Now, let this matter be listed after 2 weeks.
Date Lordship, because 2020.
Or so as to enable him to obtain instruction. Yes, next. Give the date. Give the date.
Item 49, Lordship, we have issued, the director issued the compliance order, Lordships. The rejecting the claim of the petitioner for his consequential benefit
Lordship.
of the area salary.
It may be put on record for an affidavit, because what happened in this case.
Heard Mr. So and so learned counsel for the petitioner. It is next submitted by Mr. SMT60 learned counsel for the Alice Contempt that the order of the court has order dated.
Only thing is that, Lordship, the present director is not a party.
That's,
All the respondents are already been retired, Lordship. The
Lordship, page 42, order dated
Order dated
4/3/2020.
4/3/2020 has been duly complied with. List of, however, the Mr. So and so learned counsel has objected, has refuted that the order has not been complied with. List of, considering above and as prayed for by Mr. The SMT learned counsel to bring on record the stand, bring on record the to file affidavit in office.
income is not a party, Lordship. So that may direction may be given, otherwise the.
I will say to file an affidavit. You make an
Lordship, we will
file
make
an
the present document.
formal application so that, yes, make it 3 weeks. First you have to immediately file so that he can represent.
Item 50.
Please, your lordship.
Yes.
Lodging court order reflected that we have not taken a step, lordship. I'm extremely sorry to say, lordship. We will take a step.
On the prayer of so and so learned counsel for the petition, whether a week's time is granted to take steps for service of notice upon
Respondent number 10 and 13, lordship.
10 and 13. List the matter after 4 weeks.
1052.
IA. Yes.
File or affidavit, your lordship.
What is the IA about?
Taking compliance of the interim order dated 19/1.
Huh? Yes?
Compliance of the.
Are you pressing the IA? IA? What is IA is for?
Compliance of the interim order dated 19/1/2024.
You want to file affidavit? Okay. Heard Mr. So-and-so learned counsel for the applicant as prayed for by and on the prayer of MSP Das learned standing counsel,
Secondly.
secondary education for the 3 weeks time is granted to file affidavit. Objection to the IA. IA.
As a whole, your lordship, yes, your lordship.
Item 53.
Make it fast. Yes.
Some 2 weeks time to file an.
You are for?
Reply
Four
to
and
the
six.
rejoinder affidavit.
Lordship, in this case, I lordship, my learned and friend has filed already his affidavit. I filed my rejoinder, lordship. It's a very urgent matter, lordship. I pray this matter may come up for admission, lordship. In the meantime.
What about the item? You are for 5? Who is for 5?
Lordship, as per postal report, the consignment, lordship, already they received the lordship.
Heard Mr. So-and-so K. Majumdar learned counsel for the petitioner.
Services needed are completed.
As per Lazima court order dated 27/04/2026, the service upon respondent number 5 is complete. List of next list for admission after 2 weeks.
Lordship, 1 week, lordship. I pray
In
for,
the meantime, I will.
He's going to file the affidavit. Have you filed it?
already filed, lordship.
Affidavit in opposition, he has filed a rejoinder. He has-
2 weeks.
Lordship, a fixed date may kindly, lordship.
2 weeks. Yes, next.
Any date, lordship, subject to convenience. Second date.
Obliged.
March of life, lordship.
This for what?
Hey, please, your lordship. As per the last order, they were supposed to take a decision on my issue of resignation. And they were supposed to place it before the executive meeting. However, the decision has not been informed to us, nor it has been placed in the court.
Lordship, decision has been taken.
Yeah.
Decision has been taken.
Yes.
A copy is there.
Yes.
And the termination simpliciter, which was issued, that stands and they have not accepted.
We have a
the-
stay against the termination simpliciter, my lord. We have an interim.
They have not accepted.
Huh?
They have not accepted the letter of resignation.
Huh.
I have, the facts of the facts is that they have terminated me. However, this court protected me. And thereafter I said that let me give a resignation, I leave. It was on their instance on 31st March, it's recorded. So however, what happened, they did.
What is the, why is IA for?
They stay vacating, my lord,
Huh?
stay vacating
Hmm.
against my thing that has been, I've already filed my objection. My interim is still being continuing. So my lord, what I pray, let the pleadings, as the pleading has been completed, let it fix for admission hearing.
Heard Mr. So-and-so learned counsel for the petitioner and also for
Or respondent number 5.
respondent for when? Who else are there? So-and-so, huh? And also heard so-and-so, all of them, huh? As agreed to by learned counsel party, let this matter be listed for admission after 4 weeks.
My lord, on 11th of June, my lord, a fixed.
4 weeks.
Mr. Kane Chaudhary, my lord.
4 weeks on 11 so-and-so.
And my lord, a small request, my lord, as per the last order, they were supposed to bring this through an affidavit. So let them bring this through an affidavit.
Yes, bring it.
That may be reflected, my lord.
The learned counsel for the
One.
respondent number 5.
We have got a copy, but we.
Respondent number 5.
No, respondent
It
number
will-
one
it
has
will
to submit,
be-
my lord.
it
The
will-
Union of India has to, the Ames authority has to, respondent number two has. to
The
submit.
respondent has to bring on record
Respondent number two.
by way of affidavit.
Yes.
Bring on record the what? Instruction.
He is basically wanting a copy of the
Minus
letter.
minus of the meeting. Minus of the meeting of the what is it called? Governing body.
Yes, ma'am.
Dated 28.
Petition of the governing body regarding the letter of. We
So
have got a
need a-
copy of the letter.
The respondent shall bring on record the decision of the what? Governing body by way of affidavit.
My lord, the interim order may continue.
Interim order person, yes, will continue.
Much obliged.
Yes, what is this? Where this is been listed?
Lordship.
Yes.
Lordship, in item 55, service has been completed.
Ah,
So 56, regarding the respondent number 4, item delivered as per the office note, and no status report as per respondent number 5. But all the matters are identical, and the respondent number 4 and 5 has appeared in item number 55. So I think subject to their stand, that will cover all the things.
57 and 55 formally today. And lordship, one copy has been served by him, item 59 only.
Well, I'll
the
serve it.
matters. Huh? All Mr. So and all of them. Huh? List this matter for admission.
My lord.
After 2 weeks,
My
3
lord.
weeks, have you filed the affidavit?
I'll serve it. And they have filed
3 weeks, huh? In the meantime, respondents to file their respective affidavits. Huh?
already they have filed their affidavits. This respondent number
55 and
5.
57 I have.
So that will cover all the cases.
Is it so?
Yeah.
Then you want to file more affidavit?
To instruct me.
Huh?
Otherwise, how can I say?
No, whether this will cover or not, if it's a similar matter.
Same advertisement matter, just the petitioners are different, otherwise the issue is same.
I have not received the copies even.
My lord, I will serve the copy, and regarding, my lord, item 60, that matter is, my friend told me that matter is different, so that may be
5,
segregated.
6, 7, 55, 56, 57, 58, 59, huh? Up to 15, 60, huh?
60 may be
Mr.
segregated.
So and so, learned counsel for the petition submits that. Your name, please? As we said, learned counsel petition submits that the writ petition. The issue involved in the writ petition is not connected with the other writ petition. Therefore, praise for segregation of the same, according considering above that this writ petition, that the WPC 229/2026 be segregated from the other writ petition which has been listed along with today. Huh? As spread for let this matter list after 3 weeks.
My lord, one last prayer, my lord, and one more writ petition, that is writ petition 2185, that was not tagged with similar matter, that may be tagged with this, my lord.
That is in mediation, huh? 50 to 59, huh? In the
WPC number 2185 of 2026.
list along with this thing, see? List the matter after 3 weeks along with so and so. Huh? You just get this. That will be 54.